Good morning, everyone. Thank you for your patience. We're very sorry that our training has had a little bit of delays here in the morning. We are still waiting for some of the panelists to join us. Thank you, those who are online. We are seeing your comments. Thank you for keeping time. Today, we are having a criminal law training, and I believe that at the end of this, you'll be enriched in knowledge concerning the matters that are to be discussed. Today, we hope that at the end of this training, you'll be able to understand the complexities of handling confessions in criminal trials. You'll be equipped to effectively use and challenge the electronic evidence in court. We believe that you're going to gain insight into the legal processes involved in wildlife crime prosecutions, and you'll be prepared to uphold ethical and professional standards in defending environmental and wildlife crimes. We have a number of panelists who will be joining us as we proceed. And my name is Namaweje Sylvia Bitu from Asimwe Namaweje and Company Advocates. I'll be your moderator today. And I pray that we are all going to be blessed by this training. Some of the panelists or speakers who are scheduled for today is Mr. Kamba Hassan. He'll be handling reliance on confessions in criminal trials. Then we have Mr. Caleb Alaka, who will be handling admissibility and authenticity of electronic evidence. We'll be having also Mr. Chemonges Sabila, who will be handling the prosecution of wildlife crimes, analysis of the legal procedure. Then lastly, we'll have Mr. Molly Albert Sibuta, who will be handling the effective defense of environment and wildlife crimes in Uganda. We might have a little changes in our schedule depending on the availability of the panelists and how they will be coming in. And so it looks like right now we're going to start with Mr. Chemonges, who is already present here. And he'll be one of our first speakers, and then we'll schedule the others as time goes on. But before we go into this discussion, I'd want to get opening remarks from our president, Uganda Law Society, to officially open this training. Uganda Law Society President, I believe you're already online. I would want to welcome you to give your opening remarks before we can be able to start in the discussion of this training. You're most welcome, President. Mr. President, can you hear me? Mr. President, if Mr. President is not yet here, I'm going to introduce the speaker who is present. And with that introduction, we'll be able to kick off our training. And as soon as the President is available, then we'll have to get him on board. So, ladies and gentlemen, I would want to take this opportunity to welcome you again. Thank you so much for taking off the time to be part of this training. Thank you for keeping time and being diligent. I believe that this training will be a big enrichment to you. So I'm going to request for just 1 or 2 minutes for us to get the President on board before I can introduce the speaker. Thank you very much. Good morning again. Good morning to everyone. And I want to really appreciate your patience and your presence here for this training. My name is Namaweje Sylvia Bitu again, your moderator for the day. And as I earlier stated, right now we're having remarks from our leadership from Uganda Law Society. I had earlier stated that we are having the president of Uganda Law Society, but I'm reliably informed that this has been delegated to our vice president. We are honored to have the vice president, Mr. Asimwe Anthony, who will give the opening remarks for this training, and then after he will officially open the training. Mr. Asimwe Anthony, you're most welcome. Please go ahead and give us the opening remarks.
All right, thank you, Sylvia. Can I confirm if I'm being heard?
Yes, you can be heard.
Hello. All right, thank you very much, members. Good morning, distinguished members of the Uganda Law Society, esteemed facilitators, ladies and gentlemen. It is an honor to welcome you to this CLE session on criminal law organized under the auspices of the Uganda Law Society. As legal practitioners, we operate in a dynamic environment of ever-evolving criminal practice in the areas of prosecution of strict liability offenses, authenticity, and admissibility of evidence, and challenges in recording and relying on confessions, among others. As we dive into these discussions, I encourage all of you to engage actively, ask questions, and share your experiences. Together we can advance our knowledge, refine our skills, and uphold the highest standards of professionalism and integrity in the administration of justice. On behalf of the Uganda Law Society, Secretariat and Council, I extend my heartfelt gratitude to our facilitators whose expertise will enrich our understanding today, and to all of you for dedicating your time to this important session. I would also like to extend my gratitude to the management of the Uganda Wildlife Authority for their generosity in hosting and sponsoring this training. Thank you for your kind support and for being such a valuable partner to the Uganda Law Society. We look forward to more collaborations in the future. I wish everyone the best. I wish everyone a fruitful engagement for today's session and the best of the deliberations. Thank you very much, and enjoy the training. Over to you, Sylvia.
Thank you, Mr. Vice President. We're very honored to have you this morning.
And Sylvia, with that, allow me officially open this training. Thank you.
Thank you very much. Now that our training is officially open, I would want to introduce the first speaker for this morning, Mr. Chemongez Mongea Sabila. He's an advocate of the High Court of Uganda. He has been in the legal practice for over 15 years as an advocate and legal consultant in the area of environmental protection and corporate governance. He is currently working with Uganda Wildlife Authority as the head of legal and corporate affairs, where he supervises and coordinates 7 core legal and corporate functions of UA, which include civil litigation and advisory, wildlife prosecution, wild crime investigation, corporate and board affairs, partnership and resource mobilization, and the performance, monitoring, evaluation, and reporting functions. He holds a master's degree of law from Makerere University, where he specialized in public international law and natural resources management, with his thesis topic being legal framework for the sustainable management of forestry, biodiversity, resources in Uganda. He's a member of the East African Law Society and Uganda Law Society. He's a member of the top management of Uganda Wildlife Authority. He's a former member of board of the director of Uganda Tourism Board. He is also a board member of the Natural Resources Conservation Network, an NGO involved in combating wildlife crimes. He's an advocate for environmental protection and good governance. So with this CV, I believe that you're all now very confident that the speaker before you is well versed with the topic that he's going to discuss, and I have no doubt that he's going to do justice to this topic. Ladies and gentlemen, allow me to introduce Mr. Chimongez Mongea Sabila. And this morning, he's going to discuss the topic of the prosecution of wildlife crimes, analysis of the legal procedure. So ladies and gentlemen, I present to you Mr. Chimongez. Please receive him and let us have his presentation. Mr. Mongez, you're most welcome.
Thank you so much, Madam Sylvia, our moderator this morning. Good morning, ladies and gentlemen. You're most welcome to this yet another edition of the ELS CLC workshops. This one is special to us as people in conservation. We're focusing on ensuring that district liability offenses are addressed so that we are able to all get exposed to the issues around strict liability offenses from the different sections. As the presenter for this morning, first of all, allow me to welcome all people who are attending. Appreciate ULS for this engagement, but also inform members that Uganda Wildlife Authority has been in partnership with the Law Society quite for some time. The legal department has continued to work with the society to ensure that we build a strong society, but also create awareness on some of these specialized sections of our law. Briefly, to inform members, the Uganda Wildlife Authority is an authority established by the Wildlife Act. This authority was first established in 1996, and then in 2002 it was continued when the laws were revised, and in 2019 there was an amendment, a new law was enacted that continued the authority, and now 2024 an amendment has also been effected, adding more functions to the authority. I have a presentation. The technical team is trying to put it on, but in the process I should be able to talk to our discussion this morning. What is important for us to appreciate is that the authority is basically mandated to conserve wildlife and the protected areas of this country for posterity. National parks, wildlife reserves, sanctuaries, community wildlife management areas are the protected areas that we have in the categorizations under the law. Then we have wildlife that exists in our ecosystems, in the communities. It is all vested in the authority. The key component to appreciate is that all the wildlife resources are held in trust for the people of Uganda as dictated by our constitution. We focus on managing these resources for the benefit of all Ugandans. The national parks, the wildlife reserves, and the community wildlife management areas and sanctuaries are managed by the authority for and on behalf of the people of Uganda under the public trust doctrine. And the trustees appointed under the authority manage the resources on behalf of government. The wildlife protected areas occupy over 11% of Uganda's land mass, mountains, and water bodies. So that percentage of our land in the country is held by the authority for and on behalf of the people. Of course, the authority continues to face a number of challenges. But before we go to that, the Wildlife Act now cap 315 of 2024 vests mandate of enforcing the law in terms of the wildlife crime to the authority. Of course, working with all the other government agencies responsible for criminal justice in our country. Now, the law specifically empowers the authority to carry out several operations that are intended to curb wildlife crime. And these operations range from the law enforcement itself, which involves the patrols, the patrolling, and preventing and detecting any crimes in this field. It empowers the authority to recruit and train law enforcement officers and provide them with firearms. It empowers the authority to carry out arrests of any suspects in this field, to conduct investigations, and even to prosecute wildlife crime. And this is not done by the authority in isolation, of course. The investigations, the arrests, the search, and the seizure of all tools related to crime are handled by the authority, working hand in hand with other government agencies. The authority has a very close working partnership with the Uganda People's Defense Force when it comes to operations and enforcement. It has a very good working relationship when it comes to the investigations, the arrests, the detentions, and that is based on memorandum of understanding that we have both with the APDF and the police. We have police officers deployed in the protected areas and in our offices that we work with them. When suspects are arrested, it's the police that handle the process of investigation, and all this. Okay, and all this works. So the presentation is now on, and it's been projected by the technical team. We'll focus straight into what I've already talked about. I've already talked about the mandate of the authority. Maybe the thing I can add is the fact that the authority is managing 10 national parks. Our country is blessed with 10 national parks. And national parks are protected areas of higher level of importance, where there are restrictions on what can be done and what cannot be done in these areas. The wildlife reserves are also, of course, of national importance. Now, the difference is national parks are of international level of importance, and the standards of managing them are based on international level. And that's why you see that it attracts a lot of international visitors, because they expect that high level of protection. UNICEF, IUCN, the conferences, the conventions on biodiversity management under the UN auspice all have provided guidance on the management of these areas. Sanctuaries are, of course, much low level, and then you have community wildlife areas. Now, we have gone ahead, of course, to encourage private investors who have big chunks of land to establish private ranches and farms for wildlife, and even created the blocks in communities, and because it's now an economic venture. Wildlife in our country, there is a slide there that provides the statistics. I'm not going to go into it. We'll be able to share some of this with members. We host big chunks of wildlife compared to other populations in the world. The key to mention, of course, is the mountain gorillas, where we host over 50% of Uganda's, above 50% of the world's populations, including all the other species. Wildlife, as I mentioned earlier on, is a natural resource that is of importance to our economy, to our people, and we have to protect it. The reason they create the offense and penalty as part of the process of managing wildlife is because of the value that it has. And you have to be able to deter people and give them regulated access, such that any access which is not within the regulation then is prohibited. So I list there a number of values. First of all, from the economic perspective, we generate a lot of revenue. We have the legal trade, which gives us income as a country, but then of course you also have the illegal. And then the resources that are accessed by communities through a regulated manner. The revenue we generate from tourism as a result of protecting these natural resources. So I mentioned a few figures in the slide for those who are able to see. But just key to mention is that these protected areas have different values apart from the financial. The ecosystem services that they provide, the water catchment areas. For some of, all Ugandans are following what's happening. As we destroy vegetation in some of these mountainous areas, we endanger the lives of the people. It leads into a lot of mudslides, landslides. Deforestation is leading into siltation. The rivers are losing their value. The kind of water coming from these water catchment areas. So beyond the economic value we're talking about, we're looking at the livelihood and the quality of the life our people live. The ecosystem services played by these protected areas, it becomes an incumbent upon all of us to see that we sensitize, but also play a role in protecting these places. Arrivals, of course, refers to the tourism, the visitors that come to the country, attracted by the quality of the service we offer and the protection of these areas. Employment opportunities that these areas are providing, investment in these areas, tour operations, people are investing. I've seen a number of lawyers now enjoying the space, investing in tour operations, investing in protected areas with lodges and all these facilities, leisure and hospitality. Personal, people need to go to these protected areas and enjoy and feel the country. This country is gifted. I know that lawyers are fond of flying out of the country to different parts of the world, but before you fly out, first enjoy what the country offers. It's important that the leisure and hospitality industry in this country should be grown, explore our mountains, explore our national parks, explore our wildlife, the flora and fauna that we have as the country. Of course, now there is quite some level of litigation. Lawyers have opportunity to now litigate on matters related to wildlife. We have, if you look at our wildlife law, it provides a range of areas of litigation, both against the government, but also against those that infringe and disturb. So you need to get interested in this, the opportunities in this area. The government has a lot of roles to play. Also, the public has roles to play, and we need to be able to focus on activism in that area. I wanted to mention a few challenges. Before I dive into the wildlife crime, just to appreciate that the authority in the work it does is faced with challenges. And wildlife crime will be part of those challenges that come. But just to highlight a few, we have what we call human-wildlife conflicts. This has continued to increase. The wildlife and the people are interacting. But as a result of the interaction, there is a conflict. The wildlife are destroying people's crops. The wildlife are killing people. The people are destroying the habitat of the wildlife. The people are killing wildlife. That's what we are referring to as conflict. And as a result, the relationship has not been very good. Of course, it has also resulted into a lot of litigation in this area. The government has gone ahead to come up with regulations. Under the new law that was passed in 2019, there was a commitment to provide for compensation. If someone's crops have been destroyed, government undertakes to compensate. And under the new law, the authority is mandated to put aside 2% of its annual revenues into what is called the Wildlife Compensation Scheme established by the law for compensating those who suffer impacts of wildlife interaction. Crops destroyed, human life lost, body injuries. And then the same law established what is called the Wildlife Compensation Verification Committee, which is a multi-sectoral committee with representation from Ministry of Justice, Ministry of Lands in the Evaluation Department, local governments, Ministry of Tourism and Wildlife, and then the authority. So that's a committee established with mandate to verify claims, and the compensation rates are provided in the statutory instrument. So lawyers need to have interest in this area. We've received so many notices of intention to sue from council representing victims of this human-wildlife conflict. But sometimes the lawyers don't take time to look at the regulatory framework which is there to be able to guide the clients well. Because you need to submit your claim, fill forms, have certain processes, then present it for verification by the committee. It's upon failure to get appropriate compensation from the committee. Actually, it also provides for an appeal to the minister. Then after that, if you're not satisfied, then you can go to court. But the scheme is there and it's working, and several people are getting compensated. So I thought it was important to emphasize that because this is an area of interest for lawyers. As we talk of wildlife crime, we should also be talking about areas of litigation, and we're receiving so many cases in this field. We are, of course, as an authority, the mandate is huge. The authority, as I mentioned earlier on, is managing 11% of our country's landmass and water bodies and mountains. But the human resource it has is small. We are about 3,500 staff, but the area to cover is huge, and that's why you end up having a lot of issues. So it's still some of our challenges. Of course, you know of the insecurity. These national parks are found at the most insecure parts of the country, porous borders with our neighbors, and a lot of insurgents and insecurity, which affects both our staff, tourism, but also the wildlife. We're now seeing a lot of industrial developments coming through in these protected areas, which is also a balance we must strike. You're aware of the oil, the oil exploration that's now happening in Makshon at the center of the protected area. So there must be a balance that has to be struck between the wildlife conservation and this development. Hydropower in some of the very sensitive areas. You're having road networks passing through protected areas and destroying quite some vegetation. Now you have these roads in the parks opened for public use. It definitely has huge impact on the protected areas. You can't do away with it, but we have to all work to strike balance on how we ensure that we achieve the development that we are desiring as a country without compromising the integrity of these protected areas of our country. We have, of course, a lot of competition in the region in terms of tourism, and what is of key today is high level of wildlife crime. And this range from the smallest kind of crime offenses to the highest. The highest being trafficking of wildlife specimens across. But we are diving into the next, and I will be taking you through the key offenses, which is of our interest today, under the Wildlife Act, Cap 13 of 2024. So the Cap 315 of 2024. We have offenses that are categorized as general offenses under the Act. And these offenses include any hunting of wildlife, taking of wildlife, destroying this wildlife, damaging any objects of morphological or scientific interest in these protected areas as key offenses, which are general. So it prohibits taking. But before it goes that prohibition, it's important. People say, why are you prohibiting before you even allow access? People need to enjoy these resources. We need to appreciate that entering these protected areas is allowed, but regulated. Communities are allowed to access resources, but you cannot take when you have not been authorized. You cannot hunt. Hunting, by the way, is prohibited in protected areas, but there is what we call sport hunting allowed in law in some specific designated areas of our our parks. So we have a section 30 5 of the Wildlife Act, Uganda Wildlife Act, which provides opportunities on use of wildlife resources and how you use them and how you access them. So these offenses come if people actually go against what is provided in the law. Now, these protected areas have marked boundaries and clear points of entry. So anybody who enters without permission of the authority commits an offense. And that is key for us. You want to enter the protected area, seek permission and enter within a designated point. So illegal entry is one of the key offenses, and it's the commonest, because people enter in at any time because of the porous boundaries we're talking about. Then engaging in activities, the activities of hunting, you need a hunting license. If you engage in it without a license, you commit a crime. Issues to do with wildlife farming. You have people having farms and ranches of wildlife. They don't have licenses. They don't have use rights. They are committing offenses. Issues to do with trade in wildlife specimens, as you can see there. Then there is transfer. You've been given a license. You don't transfer to another person without permission from the authority. And the penalties are given there. You can see that in the new law, there was an enhancement of the punishments. 350 currency points for a first offender, 10 years of imprisonment. But these are maximums. The judicial officials have discretion in determining the accuracy based on the circumstances, of course, as per the principles of criminal law. Now, the Wildlife Act prohibits importation of wildlife specimens into the country. It also prohibits exportation. If you want to export, you must get licenses. There is a detailed process. There is scientific authority for certifying what must be exported and the scientific authority for certifying what must be imported. But also there is what we call the CITES. CITES is the International Convention on Trade in Endangered Species of Flora and Fauna. The convention under the UN establishes in every country a framework for import and export of wildlife specimens, because now it is international trade. And for you to be able to bring any wildlife specimen into Uganda, you should satisfy the requirements of CITES. And for you to export anything out of Uganda, you should also certify. And the certifications are there, the certificates are there. Now, those who go against this certification process are the ones that fall under the category of committing those offenses, and penalties are given in there. So even attempting to, you will not have succeeded in the export, but you have attempted and you've caught at the border, you're taken on to have committed the crime. We have a few other crimes there under Section 71, which is usually the commonest. Section 71 is the commonest. The offenses there are the commonest. People are found in possession. Now, unfortunately, we are saying these are strict liability offenses. It doesn't matter how it comes into your hands. If you are found in possession, you're a suspect in this case. You're taking it from where it is supposed to be. You're molesting it. You're reducing it into your own control. Be it a species, the entire species, or a specimen of the wildlife. Someone is saying, I'm just having a skin. I don't have the entire animal. Or I'm just having the trophy. The trophies are the horns for these other animals that have horns. So, being found in possession, selling, buying, transferring from one person to another, as we've mentioned earlier, are all prohibited. And these are the commonest offenses that people commit, and the punishments are given in there. Now, just to give you a few issues you can see. Now, for those who go to the most traded species, first of all, that you need to appreciate, which it should be known to all members, is the ivory of the tusk of the elephant. It is highly demanded at international market, most especially the Asia. And so we have our Ugandans moving all the way to kill elephants just to remove the tusk. The tusk is the smallest part of an elephant, but it loses its life just because someone is looking for that ivory out of it. And you cannot kill an elephant without a gun. So you see the suspect there with a gun. And then you can see the low photo where they have put a snare. The poachers go and put serious wires and clamps, and they clamp the legs of some of these animals, and they find it suffering until it dies, and they keep tracking it. When it has gone down is when they go and remove the tusks. So this is a big challenge. The suspects you see there, some of those are having what we call pangolin scales. It's also a very small animal, but highly demanded in terms of its scales. So you can see another operation there. We have some Chinese there, and then law enforcement officers, after retrieving some of the specimens. What you see at where the officers are standing around are ivory tusks. Then on the extreme part of it is the pangolin scales. The Baganda call it logave. Yes, that animal, which is very rare because nocturnal, but they look for it and remove all its scales and leave it naked, and can't survive without the scales. And the guys are taking them because of medicinal attachments to the Asians, and it's a key challenge. Of course, we've also seen situations where people are killing lions with different attachments on the justifications, and they're exporting these specimens. So this is a serious war that we all need to come on to fight. Wildlife crime steals from all Ugandans, steals from the country, and steals from the globe, because these resources must be protected for posterity. When we are enforcing the wildlife crime law, we are really focusing on protection of the resource. There are many other methods of protection, but wildlife crime as an approach is of interest, of course, to the lawyers. We know that we have defense counsel, we have prosecutors, we all have a role to play, the judicial, and the key thing is, at the end of the day, we want justice for nature, but also for the people involved in this. So those are the key offenses under the Wildlife Act that I thought we needed to share today. And these are strict liability offenses. When you're found with this, you definitely have to answer. Now, just to give you a brief on the statistics for 1 year, 23-24, we recorded 1,215 cases connected to wildlife crime. And of course, the suspects range from the youngest to even old people of 60 years involved in this crime. And both males and females are involved. But you see, the majority are the males there who go into the bush to kill these animals. There are those who are found picking the simple things for their own survival. We balance off and see they have gone against the regulatory framework, because the communities are allowed to access certain resources on specific days, guided by the law enforcement officers and community liaison persons. But in many cases, you find that they have also gone off. Although those are managed negligibly at the lower level, what we record are key offenses that are really criminal. People are doing this in the interest of economic getting value, getting money out of these cases. We are working with the state attorneys. We are able to discern and check which offense, which case and which suspect should be prosecuted, and which ones are handled at that level, depending on the level and the involvement. So we are not insensitive to some of these issues. Now, you need to appreciate that out of the cases of 2023-24, we had 582 accused persons who were actually sentenced. You have those that went into jail, for imprisonment. You have those that paid fines, others to community service, as represented there in that chart. So it's important for us to appreciate this is a serious claim. The prosecution is happening across the country. I'll still give some bit of statistics there. Now, we have categorized our protected areas into administrative zones. And when we are managing crime and when we are reporting, we report from each zone. And that's what I'm saying. It happens across the country. You have suspects. In that chart, it is giving you based on the area. Maction Falls is reporting the highest. About 31% of the cases are coming from Maction Falls. You have another big number coming from the Rekmburo zone, Queen Elizabeth, with 20%. So the chart is providing you the cases as per the regions. You're having Mount Elgon with over 7%. Yeah, across. So that chart is providing that. So we report all the cases coming from the different regions. And we have teams in all the regions handling these cases. We have prosecutors in every region working with the office of the DPP and the state attorneys there working. We have investigators in those regions, intelligence officers who do the detection on information in all those regions. So now the authority, as I mentioned earlier, is empowered to carry firearms, to conduct operations, to arrest suspects, to conduct searches, seize exhibits, prosecute offenders, but of course also to dispose of equipment used in crime, most especially after the court process is concluded, and the courts usually make orders to have those exhibits, both with the wildlife specimens, but also other tools and equipment used in the commission of the crime are forfeited to the authority and they are disposed of. The law provides the procedure on how the disposal is done under section 78 and above. They provide the process and procedure on the disposal. The executive director is given mandate to ensure that this disposal is done within the confines of the law. Now, in the process of combating wildlife crime, the authority has established relevant units that are working with other agencies of government to process cases, conduct investigations, do analysis, and ensure that suspects are presented in court with evidence. We have a law enforcement unit, which is the largest unit actually in the authority, that carries out general operations. Then we have intelligence unit that gathers information on and detects crime. We have investigations unit that then does the actual investigation, working with police, prepares files, working with police, and ensures that evidence is gathered. And we have a prosecution unit, which is licensed by the DPP, that conducts the prosecution of our cases. In those units doing their work, they work closely with the agencies I mentioned earlier. The UPDF provide firearms to the rangers and our law enforcement officers, and they work together in carrying out the operations that are intended to combat wildlife crime. We have the intelligence unit working with ISO, with ESO, with CMI, with DISO, with PISO at the local levels to ensure that anything related to wildlife crime is detected. We have the Uganda police that works very closely with our investigators in handling suspects. We ensure that suspects are handled within the law, the suspect's rights are respected. The detention is only in police. We have no detention centers. Whereas we do the arrest, we take all suspects to police. We work with the police in preparation of the files. And we also work with the forensics, because you may realize that wildlife specimen, if they present for you meat of a buffalo, someone has hunted, you may not be able to differentiate it with the meat of the cow. So we do a lot of forensics. The authority has built some level of forensic capacity. We've established a forensics lab based in Queen Elizabeth with the support of the American people, USAID, and we have also continued to have a mobile lab that is based in Kampala that does analysis on some of the specimens. We send them out of the country to be able to get appropriate analysis, working with an organization called Trace Forensic Network. We, of course, enjoy a very good working relationship with the DPP. We have about 25 prosecutors that handle wildlife crime in the authority, and licensed by the DPP and supervised by the DPP. We work with the state attorneys at the regional level who supervise our prosecutors, who sanction our files, and ensure that whatever is being done is within the law. The judiciary has played a key role on the realization that wildlife crime was becoming a big problem in the country. Our country had become a conduit. People will do the crime across in Sudan. We'll have consignments coming from Burundi, from Congo. They use Uganda as a conduit, and that was not giving us a very good image as a country at international level. And we had been blacklisted by the UN. But that was about 2008, 2010, up to 2012. Government sought it wise to establish standards utilities court, which was dedicated also to handle wildlife cases, in addition to all the other courts handling the cases. And this has played a key role in ensuring that the wildlife crime cases are given special attention, and we've registered quite some level of success in curbing crime. We established a sniffer unit, dog unit that sniffs wildlife specimens across the border for those who are transiting. If you are going through the airport, you will see wildlife officers with dogs that sniff and check if someone is transiting with products of wildlife crime. And this has helped, given us some level of sanity. The international criminals and syndicate players in this field are now trading very carefully when it comes to using Uganda as a conduit for wildlife crime, because the effort of combating it has gone to another level. We work with the prison service deliberately to ensure that the suspects that we take to prison, we engage them to get the network, because we want to look at the entire network of the crime, but also to help them get rehabilitated, and when they come out, they are not going back into wildlife crime. And we've been able to get a lot of good leads and information by engaging with the prison service. There is a bit of noise here in this presentation. It was trying to give a scenario of a case that was handled working with URA Customs, where several specimens were confiscated, both pangolin scales and ivory. We have been having a unit called Wildlife Crime Unit, a special unit, which is like a quick response unit. We established it working with an NGO from the US called Focused Conservation Solutions, and these have done a very good job in dismantling the trafficking networks, and they are supporting us in carrying out forensics, in coordinating with Interpol, following suspects across border, and it has yielded some good results. So what is key for us to appreciate is the fact that we've continued to register good success in prosecution, working closely with the DPP's office. And we want employer, we have Defense Council, they will share their experience, but we worked with you in ensuring that most of these cases, by the suspects confess to the crime. They plead guilty in most of the cases because of the strictness, and we focus mainly on on mitigating sentence and reformation. And because of that, the plea bargain process has played a key role in managing these cases as well, because suspects quickly appreciate what they have done. Some of them think what they were doing was wrong, but many of them actually, from our statistics, know that what they are doing is wrong. But the plea bargain processes have been of help, following the guidance from the guidelines issued by the Chief Justice in this. So, Madam Moderator, as I conclude, just to inform members that, and this is a reminder, that we have a role to play in combating wildlife crime, because wildlife crime steals from all of us as a country, steals from us, steals from the generations to come, steals from our economy. I've given you the value, the economic value of wildlife. Wildlife is a key resource for our country. If we don't fight to stop the crime, then we lose. And if we lose the war, then our generations that will come in the future will face it rough. So we want to encourage you to honestly participate with us in this field of wildlife crime, but also encourage you to get interested in issues related to wildlife. Get a copy of the Wildlife Act and go through it and look at the opportunities that this part of the economy brings to you. You will be surprised that as a lawyer, there are investment opportunities as well, which I've mentioned in the other parts. We don't just focus on the crime, but we focus on the entire opportunities that come from this field of law. That really marks the end of my presentation. I want to thank you so much for giving us the opportunity to share with you our experience in combating wildlife crime in the process of prosecution. Our team is doing a good job. We appreciate all those that are supporting us, and we encourage all of you to join us in this battle so that we ensure that we get rid of this. I know it is very difficult to get rid of a crime when the resource is quite attractive, but we have to do our best to bring it to minimal levels and focus on the economic benefits and opportunities from the wildlife sector. I thank you so much, Madam Sylvia, our moderator. All those who are listening to us, who are following us, we appreciate, and I'm sure that you'll be able to pick leave from this. I'll stop there for now. Thank you so much.
Thank you very much, Mr. Chemonges, for that very elaborate presentation. You have gifted us with a lot to learn and a lot to be able to consider and think through. Thank you so much. We thank you, Uganda Wildlife Authority, for the commendable work you do to preserve our natural resources. We cannot underestimate how important your work is to this country, for the resources that you preserve and for the animals that you ensure have an opportunity of remaining still part of us, that the next generations shall be able to know that these animals actually existed. We will not take questions at this time because Mr. Chemonges' presentation is also connected to the next presenter's presentation, and I thought that it would be nice to have them both, and then would have questions after that. However, there is just one that I'm going to engage in before I call on our next speaker. Mr. Chemonges, the obvious one. I'm a defense lawyer, and so I will ask you the impossible one on your side. What are some of the defenses? What are some of the defenses that a defense lawyer would be armed with when faced with some of the crimes that you have just elaborated? Because many of us are defense lawyers and we're trying to get our clients out. So I know you're on the prosecution side, you're always armed to ensure that our people are in. For us, we're trying to get them out. So what are some of the common defenses that would be available to an accused person for many of the wildlife crimes. Thank you.
Which answer should I give? Yes. Always, defense counsel finds a way of finding a defense. But under strict liability, the defenses are usually very minimal. Very minimal. If you kill a buffalo, for example, what defense will you give? Defense of self-defense? Maybe. You should be able to demonstrate that it had endangered your life and you killed it in self-defense. But if you killed it in self-defense and you go ahead and pick the meat to eat, will that defense still stand? So those are some of the dynamics, because you find that people have killed, but the defense used is not coming out well. We have killing in protecting what? Others and property. Yeah, it's defense. It's still a defense related to self-defense, but the circumstances surrounding such defense should be presented, and the law provides the process. If you kill in self-defense, you should be able to report to the authority. You should be able to, even when you injure and left it when it is moving, it is still alive, but is injured. You should be able to report, because it becomes more dangerous, more aggressive to other people. And if you did not report, it would be very difficult for you to rely on that kind of defense. And if you kill, have you surrendered the carcass, or you have converted it into into a meal on a plate? So some of the issues we deal with. We have defense of accidental killing. Now with Maction Falls being open for traffic, public transport, people are moving through. We're losing a lot of animals being killed, and accidental. But accidental, now we also look at, what about the speed limits that are set in these areas? Were you observing the speed limits so that your defense of accident can stand? So you look at all those circumstances to be able to, and then after killing, the officers are along the road. Have you reported that you have killed, or you've just run away and you are arrested subsequently? Because we have cameras in some of those areas, and we're able to get the number plates. So your client should be able to come clean, to be able to benefit from some of these defenses. Because really these are defenses of equity. You should be able to come with some level of cleanliness. Otherwise, accidental killing, if it does not really fall within that, you'll be penalized for that. But those are the main defenses. Most of the time, these people plead that they were not aware that they were committing a crime, and ignorance, which is not a defense in law, but is the commonest plea that many of them provide in district liability offenses. So it's quite, the key thing is to sensitize the client to ensure that they avoid the crime. That will be the most appropriate defense. Thank you, Madam.
Thank you very much, Mr. Chemonges. Thank you for that, just a tip of the defenses. I hope that the listeners have at least taken a leaf. You can find a way of ensuring that your client does not end up in a precarious condition because of the strict liability cases, depending on the defenses as have been elaborated. Thank you so much again, and thank you, Uganda Wildlife Authority, for having us here, for hosting and enabling this training. We are very grateful. We have our next speaker. Our next speaker is ready and present here with us, and I thought that he would take on this, and after him, then would have questions, if any, and the two speakers would be able to discuss both questions that will be put to them, because the topics they are discussing are related, and I thought that both should be handled at the same time in order for us to be able to have a meaningful discussion. And so, ladies and gentlemen, Our next speaker is Mr. Molly Albert Sibuta. He is an advocate of the High Court. He is also a lecturer at LDC. I know he's known to many of you. I know him to be one of the criminal law gurus, and so he's going to give a good justice to this topic. The topic that he's going to discuss, the topic that is going to be discussed by Mr. Albert concerns the, just a minute. Yes, he's discussing the effective defense of environment and wildlife crimes in Uganda. Actually, the question that I asked the previous speaker was a precursor to this discussion. Him as a defense lawyer is more equipped. I wanted to hear the prosecution's side of our defenses, but now the present speaker, Mr. Albert Sibuta, is going to effectively give us the defenses on environment and wildlife crimes in Uganda. Mr. Molly, I welcome you, and I request that you give us a brief introduction of yourself, because I know I've not done enough justice. I would want you to be able to address everyone in your full capacity. Thank you very much. You're welcome, Mr. Molly.
Thank you, moderator. Good morning to you all. I take the honor to thank Uganda Law Society and Wildlife Authority for this arrangement. Molly Albert Sibuta is my name. Practitioner of criminal law for the last 20 years. 10 years as a prosecutor, 10 years as defense counsel, 11 years as a lecturer, criminal proceedings. I believe that is good enough. Okay, thank you so much. The topic for me to share with you is about effective defense of environment and wildlife crimes. I want to take the honor to thank Mr. Chemonges for the preamble that he has given about environmental crimes. I had prepared for that, but now that we have heard from the host himself, I may not repeat, but just to emphasize, of course, environment is broader, although wildlife authorities mostly interested in wildlife crimes, but the Utilities Court is doing a broader, trying more than that. Other than wildlife crimes, you're having forestry. Okay? NFA is also prosecuting persons who are contravening the act. We have fishing, crimes related to fishing. You know very well that there are prohibited degrees in terms of the fish and the gadgets that we use for fishing. You have pollution. National Water and Sewage Corporation is doing a lot of prosecution in this field. And of course, we know the examples that are on in respect of pollution. One time I was working in Ijinja, I think 2008, and I think that industry is called the Skyfat. There is a way it emitted its waste products, and the whole town went into, the whole town was full of foul smell until administration had to take action. So that is pollution. But we also have destruction of protected areas like conservation areas, among others, which may fall under Wildlife Authority. Now that one is between Wildlife Authority and NFA, some of those conservation areas. So environment is not necessarily about wildlife, but it is stretches as far as what I've just highlighted. Now, as the defense counsel, what do we expect of you? Surely, I want to share the experience that I got from the head anti-corruption court. Justice Gidud, one time he comes to Law Development Center to present a paper to our students on cybercrime. And his explanation was that Defense Counsel have failed to appreciate the distinction between the ordinary crimes under the Penal Code Act and specialized crimes. And that is something that we need to appreciate. Whenever you're getting instructions, ask yourself the area that you're going to defend. Okay? If your person that is used to defense in the General Criminal Division, you see usual murder, defilement, robbery, etc., the approach becomes different when we come to specialized crimes. So what is required, first of all, is your knowledge in the subject. Okay? Your knowledge in the subject is something that is very key. How much do you know about environmental crimes? If you're taking instructions, say, for defense of wildlife, how much have you addressed yourself to the Wildlife Act? What of the related laws? What of case law? How much have you read that you're going to apply in your defense? Now, I just want to make the latest, about 3 weeks ago, students promoted Kamasanyu to justice when we had a workshop on wildlife crime. And the fact is we have few precedents about wildlife crime. So in the course of their research, students share with me and a few other colleagues, Justice Gladys Kamasanyu in the case of this and this decided. So I was wondering when Gladys was promoted from Chief Magistrate to Judge of High Court. But the issue is, if you Google, all the information you're going to get is coming from Wildlife Utilities Court, and most decisions are by CM Kamasanyu. Okay? So how much research have you done before you actually delve into? I personally have, I don't know whether I'm too straight or I have a problem, that if you came to give me instructions in something that I'm not well versed with, I'll decline, because I don't want to give you shoddy representation. Okay? So the aspect of preparedness and knowledge in the field that you're going to engage in is very important. Okay? So now, having gotten the knowledge, what action do we see as Defense Counsel that can help us have effective defense? The first thing I implore colleagues to do is networking with professionals in the field. Not necessarily fellow lawyers, but engagement with professionals in the field that you're going to defend. If you're talking about wildlife crime, ask yourself, the species has been killed. Of course, we go to utilities court, and my friends come with the smelling meat, where they will tell the magistrate, you see, this is buffalo meat. The question is, how do you distinguish it from beef? Or how do I distinguish it from antelope or warthog? Okay? That means you're supposed to get an expert, either veterinary expert or whichever expert in the field, that you can also engage and find out what steps are taken for us to reach a conclusion that this is wildlife species. Okay? Again, I have to share my experience. My first case of murder in 2004, they sent me a police file. Murder. And what was it? Cause of death, hemorrhagic shock. Okay? Yes. So what do I do? Straight from LDC, a few months in practice, you have to decide whether to charge or not to charge. But good enough, I had a few contacts in the medical sector. I had to call the medical soup of Guru Hospital. Dr. Tim, what is hemorrhagic shock and how does it come about? Then he had to explain. Then I called also another doctor we buried 3 weeks ago, Opira, from Mulacho Hospital, because I was not satisfied with the explanation of one. Still, I had to read for him the contents of the medical report. And they too gave me the same conclusion, that is overbleeding that results into loss of life. Then you come and see the gadget body parts and reach a conclusion. So if I had no connections with a profession, a colleague in the other profession, in respect of the subject that I'm handling, it wouldn't have helped me to reach a conclusion. So my appeal to colleagues in defense, yes, we are learned, but we don't know it all. So engagement remains very pertinent if we are to do defense. If I borrow a leaf from anti-corruption, most of the cases in anti-corruption court, I did one on roads where they had charged an engineer with shoddy work. But I also had to engage engineers of UNRA, okay, to take me through road works, how much is bitumen, what is supposed to be mixed, what levels of a road, that when I come to court, at least I know what I'm talking about. But with the aid of colleagues from the profession that you're defending. So you don't have to say because it's wildlife or environment, I cannot contact. We have people who can help us build a better strategy. That is one. Then two, we have pre-trial intervention. As a defense counsel, you don't just get instructions to go to court. I personally don't like appearing in court, although we are trained to do that. But if I can have a matter settled out of court, that will be my best. I take the little money, but it saves on my time. So what are some of the pre-trial interventions? One of course, the fact is we have to know the 48 hours rule. So now I'm sorry, I'm going to use the examples of wildlife. Okay? A person is arrested from Kasese, Queen Elizabeth. He's kept at maybe Kasese police for 2 days, transported to CPS Kampala. They are also keeping him for 2-3 days. You're sending the file to DPP for perusal. Like today and tomorrow, DPP staff are engaged in their end of year activities, so nobody's in office. How many days? 6. But for you, you're saying, no, let's wait for the day of court, well knowing that we can still help this person. So what would be the action? It does not hinder you from pushing for a police bond. Okay? After all, police bond does not take away the guilt of someone. Push for police bond. That's one. 2, still push for intervention by DPP's office. Are we certain, are we very sure that there is concrete evidence? Let's lodge a complaint to DPP's office and have this file called as soon as possible. Let it be perused and we ascertain whether there is sufficient evidence that warrants prosecution. If not, again, DPP can help us either to have the file closed, have the file go back for further investigations, or if they find evidence sufficient, that's when they will go ahead and sanction. But you've taken a step to push in favor of your client. Then the third, if we failed in the first 2, still pre-trial is the application for unconditional release. There is no bar for us as a defense to go to court for unconditional release as long as the person has stayed beyond 48 hours. Okay? So the most times when we get information or instructions, we tend to sit back and wait for court. Okay, let the police conclude investigations, then we wait for court. You know me, my work is to wait and apply for bail. Okay? My work is to apply for bail. But incidentally, we can even do what? Be better without going to court. So that is step 1, pre-trial intervention. Now, should we fail at pre-trial intervention, what advice do I offer to my colleagues still? Again, I told you that I'm not a fan of full trials because we spend a lot of time. Mr. Chemonges just appreciated the CJ for the guidelines. We have plea bargain rules. Okay? Why can't you consider plea bargain at the inception? That's another strategy. Consider plea bargain at the earliest time possible. Okay? What does that help? For me, it helps me because the judicial officer has not gotten so much information about the matter. So there is little that he or she knows, not so much influenced at that moment. Okay? Vis-a-vis a situation where we first go in, please taken, you have 1, 2 witnesses. Now, when you realize that the case is going to collapse on your side and your client is going to be convicted, then you come up and say, no, now my client wants a plea bargain. If we had considered it at the inception, it would give us a better result than waiting to go through some steps until, and then subsequently you recall and say, no, let's go for plea bargain. So I implore my colleagues to always have this aspect of having plea bargain at the fastest instance before you think of full trial. Okay? So then, we have now come to court for full trial after assuming the two have failed, and we now have the next step as full hearing. What do we expect of you as counsel? On day 1, we are looking at the liberty of your client. That is part of defense. Liberty of your client. So on day 1, upon plea taking, we expect you to apply for your client, bail for your client. Very key. Although the MCA says that the court shall inform the accused of his right to apply for bail, but as a counsel, we expect you to play your professional role. Again, I share an experience with a colleague who shared with us how he got instructions to go to Uganda Road and defend a client. Unfortunately, this was an investor. So matter is called, please taken, our colleague is seated. Please taken, the prosecution informs the court, investigations are complete. Remember, you've gone on record as counsel for the accused. The investigations are complete. The colleague is seated. Court looks at him. What do we expect of you? Obviously, to address court in terms of bail application. So after the magistrate keeping quiet for about 1 or 2 minutes, and everybody was looking at the advocate, the next thing is you're remanded for 2 weeks. And that's when the colleague woke up, no, your worship, I have instructions to apply for bail. You know? So again, you go to court when you know what you're supposed to get for your client at every time. Any stage you go to court. So at plea taking as defense counsel, bail application, very key. At least you first secure the release of your client before you think of any other action. Okay, so assuming bail has been granted and now we are preparing for full trial, what is expected of you? Acquiring disclosure as soon as possible. You cannot claim to defend if you have not appreciated the contents of the police file. No. So disclosure. Make sure the prosecution gives you sufficient information. Even if now, like for environment, you expect exhibits, either physical or documentary. So don't only expect or call for the 5 statements of police of witnesses, but what are the intended exhibits that these people are also likely to use? What of the expert evidence? Are there any reports that these fellows, the prosecution is likely to use? So the disclosure should be as exhaustive as possible, so that it helps you to prepare your defense strategy. Then after you've gotten the disclosure, you've gone through the contents. That is when you can appropriately advise your client. Should we go for plea bargain? Should we? What is your take? You see, I'm reading, they got ready-handed. My colleagues of Wildlife Authority, you remember your case of Kroma. Is it Bangale Kroma? Now, that case has said something, a good thing most lawyers don't read it. So, but I know of a fact that most lawyers are not aware of Bangale Kroma. Okay? Yeah, but as defense now, I can give you a hint. That the fellow is prosecuted, High Court convicts possession of wildlife species. But what was it? The 3 or 4 persons are in a motor vehicle. Then when they are stopped, 2 of them take off. Now this one remained in the vehicle. And when the vehicle is searched, species are found. And we conclude that, you see, since you're in the vehicle, you were in possession. High Court convicts. But when it comes to Court of Appeal, the justices say we must distinguish between actual and constructive possession. Okay? And now that the fact that this man raised the defense that for me I was not aware of the contents in the boot, you cannot say that he was in actual possession. Of course, painfully, the Court of Appeal overturned the decision of High Court and says this is merely constructive possession and you cannot attach it to the accused. Probably it is the ones who took off that were guilty. So unless you bring them to book, you cannot conclusively say that this one who remained in the vehicle was in possession of the species. Okay? By now, all that is information you're going to get after you read the law, you read the facts, you appreciate, then you come to court for defense. Okay? Then, you've gotten disclosure, again, come forward to consider the appropriate defenses available to your client. Unfortunately, like Mr. Chemonges said, most of these are strict liability offenses. So being strict liability offenses, we are limited in terms of defenses. But I may not repeat, he gave us an insight of accident, which is not so common. He gave us the example of self-defense. That one is actually, I think, I've not seen anybody raise self-defense. Maybe the prosecutors of wildlife can tell us. If you're being prosecuted for cutting down forestry, can you say raise self-defense? No. Can you raise accident? That the thing was falling on me and I decided to cut it? It's not possible. You're found with illegal fishing gear. Surely, what defense do you have at hand? So at the end of the day, it becomes something challenging. So maybe for wildlife crime, yes, you can have 2 or 3 like the director told us, but when we compare with other environment crimes, we have limited chances of possible defenses. So at the end of the day, you're going to go to court, but you're just praying to play around with the witnesses, but which we are not certain of, but it would be very ideal for us to appreciate the possible defenses available to a client before we start prosecution. Very key. Okay? Then, what would be the next strategy? We now have hearing. What is the role of counsel for effective defense? We expect effective or thorough cross-examination of witnesses. Whether laypersons or professional witnesses, experts, you must play your role as defense counsel. We all are alive to a fact that failure to cross-examine shall be considered as an outright admission of examination in chief. So if you can't cross-examine, then it means you're laying a passage for prosecution to proceed and secure a conviction. Of course, as defense, for us, our work is to see at least one of the ingredients of the offense. Now, again, we are coming to wildlife, protected species. That is what they are supposed to prove. And that is where we should delve so much, confirm how much do you know, how do you convince us? If I brought here 5 pieces of meat, one picked on Tuesday, the other one on Friday, the other one on Sunday, are you able to distinguish that this one was 2 days older than this, among others? You're trying to make, now this is an expert whom I have to try and make unreliable. Okay? So if I succeed in making him unreliable or failing to answer most of the questions to the expectation of prosecution, then I can comfortably convince court. The prosecution failed to prove the ingredient of protected species. Yes, the man was found in possession, but to what extent can court believe that this is not ordinary meat? Okay, that is submission at no case to answer. The two factors in FX Kayemba versus Uganda. But then we also have the final submissions in case the client is put to his defense. Again, as a counsel, you have a duty to submit. Now, my colleagues in prosecution, like as I was, we have a tendency of telling court, I leave it to court. Prosecution, you will use our file submissions, or are you ready to make oral submissions? No, we leave it to court. Simple. Now, as a defense, are you also going to leave it to court? Of course. Are we on or off? Oh. Oh, God. Fine, Hassan.
Hello? Yes, I believe we are back on now. Sincere apologies to our members online. We had some technical issues here that made us get off briefly, but I would like to invite our speaker, Mr. Molly, to continue with his presentation. Sincere apologies.
Okay, thank you so much. Friends online, we do apologize, like Sylvia has said. I think I'd stopped at a point of Defense Council making effective submissions, and my emphasis was on the fact that there are two levels of submissions: submission at a no case to answer and the final submissions. And we did mention that at no case to answer, you have two areas of interest. One, that the prosecution has failed to prove at least an ingredient of the offense, and I gave the example that in wildlife crimes, the main issue we can challenge is the fact of failure to prove that this specimen is of a protected species. And that will depend on how you cross-examine the expert, not the ordinary police officer, but the expert who comes to confirm that I carried out the test, meaning that you as a defense attorney, you must have also read how examinations are conducted in terms of such specimen. If we don't, then it becomes a challenge. But two, if you have also effectively cross-examined to the extent that court believes that the evidence on record is unreliable to secure a conviction, if a person is put to his defense and he chooses to remain silent, then you can still emphasize your submissions for no case to answer. But should the court go ahead and find a prima facie case against the accused, then we expect you, of course, to present a proper defense strategy. Section 127, which gives you the three options. Is your client going to swear? Is he not going to swear? Is he choosing to remain silent? Depending, again, that is purely professional part which defense counsel is expected to know and advise the client. Of course, irrespective of the option, a person shall not be penalized because it's his right, statutory right. But it is upon you to say, if at all, I advise the accused not to swear. How much is going to be put on record? Supposing he takes oath and is cross-examined, is he able to stand firm and answer questions by the prosecution? If not, maybe we choose that he remains silent and the court evaluates the evidence that was laid by prosecution to reach a conclusion. Again, that is something that the defense counsel must have in mind. Okay, then finally, after defense has been given, what do we expect of defense counsel? Final submissions. And final submissions can best be done if you have case law to support your arguments in respect of each and every ingredient. Try to research as much as possible. It may not be true that Uganda has little jurisprudence on environmental crime, but as East Africa, at least Kenya has done a lot. Kenya has a lot. I think we have over 15, 20 cases now from High Court Kenya, which can guide us in defending our clients. And TZ, our brothers in TZ also have come on board. So even if we are still lagging behind in terms of jurisprudence, we have to stretch further and research within East African region or even outside the region, as long as we know that the authorities are going to help us convince court in favor of our client. That is final submissions, or basically that as counsel, you're expected to prepare proper submissions at the two levels of trial. Okay? Then what would follow, of course, judgment, which is a duty of court. Now, assuming if you have secured an acquittal, well and good. But assuming the court convicts the accused person, still as defense counsel, you have a duty of advancing appropriate mitigation. Appropriate mitigation. We address our mind to the sentencing guidelines because prosecution is going to give us a lot of aggravating factors. And the amendment, okay, now the current Wildlife Act, you know very well that it gives life imprisonment. Life imprisonment if you're convicted in respect of possession of protected species. I think section 71? Yes, life imprisonment. Now, are you going to let court take your person in for life? Of course not. What would be the best? I personally wish to always have a non-custodial sentence. The person has carried a conviction, no problem. But can I secure a non-custodial sentence? If yes, then still you'll have played your part. But that depends on how you arrange your mitigating factors. You consider the age of the accused person. Is he very old? Now, like wildlife, we get very old men who claim that they were poaching for medicinal purposes. So if we give him 20 years, is he likely to come back alive? Of course not. What of the medical conditions? What of society obligations, family, among others? Now, some of us have gotten used to the song, a first-time offender, he's remorseful, he prays for leniency, full stop. Now, have you guided the court on the leniency that you want for your client? Very key as defense counsel. My personal experience is in one of the files in anti-corruption court. These fellas are convicted for causing financial loss, 487 million OPM money. And obviously, the state knows these fellas are going to prison. Now, I was representing a lady. By good luck, she had a child of about 9 months or so. She gave birth during trial process, in the course of the proceedings, because it was over 2 years. So I told Safina that on the day of delivering the judgment, make sure you come to court with your baby. And she was taking care of her parents, elderly parents. So I told her, make sure the parents have also come to court. And then she had 2 other children who were school going, but in nursery and P3. I told her, make sure you come with those school going children as well. Now I paraded 4 people before Justice Gidudu. I told him she's a single mother, looking after her parents, elderly, who are sickly. She's also the one paying the biological mother of these 2, nursery and P1. But more so, she's also breastfeeding. Okay? Now that is a strategy that some of us may not have known. But so I told the judge it would be unfair for a single mother. So meaning all these 4 or 5 people are going to remain helpless. And this 9-month-old child is not supposed to go to prison. So where will he go? Obviously nowhere. So my Lord, I pray for a fine other than a custodial sentence. And indeed in his judgment, when you read the case of Papa Moses and 3 others, High Court. No, that was Arinaito, yes, Arinaito, yeah, that's the one. Papa Moses and 3 others. At the sentencing, you'll find that the judge said, okay, I considered the mitigation and the social factors, and I have to give a fine. Similarly, we can do the same in these environmental crimes. It's not a given that because the law says the maximum is life imprisonment. I don't know if I can be heard. Yes. Okay, thank you. So that was just one. If you have a person with medical illness, can you bring evidence? It is not late at mitigation. Bring the documentations and throw them before the court. This man is going to die in prison. Or any other factors that can persuade the court to give a non-custodial sentence. Very important. It's not a given that prosecution should always secure a custodial sentence. For me as a prosecutor, as long as I got a conviction, because the returns would say conviction, I don't include the number of years. Is it a conviction? Acquittal. Conviction. That is their work as prosecution. But for you as defense, conviction. But now, what type of sentence have you secured for your client? So don't just sing, we pray for a lenient sentence. Propose, even if it is the prosecution is insisting on custodial, suggest the least number of years that you may wish your client to get. My Lord, even 1 year is sufficient for him to learn. Then let the court decide. But don't just say, I pray for leniency. He's a first-time offender and he's now remorseful. Of course, we can't prove remorse. Okay? So that is the duty of defense counsel. Effective legal representation as a defense attorney. Now, finally, if a sentence is meted, do we just step out? Even the court made mention that you have a right of appeal within 14 days. The question is, still engage the offender and advise him. Okay? Yesterday I received a call from prisons. A sentence was confirmed by the Supreme Court. By these fellas are saying, counsel, we want you to apply for review of the sentence. Of course, we have Obote versus Uganda, which opened up that thing of review of sentences by Supreme Court. But these fellas, any other lawyer would think, after all, Supreme Court has finally confirmed. But the fellas are still saying, no, let's give it a final shot. Counsel come and we give you instructions to apply for review of this confirmation of sentence. Similarly, you can advise, be helpful and advise your client on the possible appeal. And then it will take us back. We identify, was the procedural issues well followed? What of the sentencing? Was the mitigation considered? What of the sentence itself? Was it lawful or illegal, among others? But of course, there you have to first ask yourself whether you will be retained as counsel on appeal or not. But even if you're not going to be retained, at least professionally, you will have advised the fellow that this is not the end of it all. The gates are still open for you to seek justice. Okay? And having exhausted that, simply that is what we expect of you as defense counsel, to effectively represent your client. But as I sum up, I again implore our colleagues that let's not go to court when we are not prepared. Preparation is very key. Knowledge of the case file is key, but again, knowledge of the subject matter. Knowledge of the case file, I refer to police statements. But knowledge of the subject matter, I'm referring to you taking a step and read further than the police file. And like I said, engagement, consultation, networking will always help us in our defense. And then in the court, make sure you're available to your client as and when you're required to, and be available and be courteous. Do you play your role as defense professionally? If that was done, we believe that we shall achieve as defense counsel. That is it. I thank you so much. And once again, I thank ULS for considering me as one of the presenters to this training. Thank you.
Thank you very much, Mr. Molly. You have really blessed us with a very practical approach. It really gives you justice as a lecturer of LDC. You're teaching students of what they actually have to do. So we thank you for that. And I'm sure that our audience has benefited a lot from your presentation. Right now, we're going into a question and answer session. So I request our audience to make questions, to raise any questions, both to Mr. Molly and our first speaker, Mr. Chemongez. If there are any questions concerning wildlife practice, they're welcome right now. Do we have any questions? You can raise your hand. You can share a question on the chat. We'll be able to pick it up from there. So if anybody has a question, please let us know. Otherwise, if we don't receive questions, we'll follow the program and proceed with our next speakers. So can we take it that the presentations have been very satisfactory and we have no questions? Hello, our audience, are you there? I see there's a question on the Q&A. So the question is, what is the position of the law on wild animals like monkeys? On private land like a farm, I know of a person arrested by police allegedly for poisoning monkeys on his farm. And I think this question will go to Mr. Chemongez. Do we have another question? Did we have somebody raising a hand? No, we haven't seen a raised hand. So we can have somebody's asking at what time do you bring up your defense to court? This question is from Mr. Tusingure Andrew, and I think that question will be answered by Mr. Molly. Any other question? Okay, I think we'll answer the two questions, and if any comes up, we'll be able to address them. But for now, I want to invite Mr. Chemongez to answer that first question.
Thank you, Madam Moderator. And the question is the killing of wild animals on private land. As I mentioned earlier on, wildlife and wild animals in our country are not confined in the protected areas. They are protected by law wherever they occur, be it on your land, be it in any public place. They are protected. So you have no right to kill any animal that is on your land. What you can do is to report. If they have become a menace, a nuisance, you report to the authorities. They are in the law animals that are regarded as vermin. Vermin means they have become a nuisance in the community, and the minister is actually supposed to issue a statutory instrument gazetting them as such and authorizing the local government to cull or reduce their numbers, and they are killed. So the authority has a responsibility working with the respective local government to ensure that such animals are managed. So if you have some on your land that have become a problem, you report. You report to the next office of the authority. Districts have now established vermin guards under the Natural Resources Department at the district level. You also report, and they work with the authority. They can relocate away the animals that are on your private land. They can also come, and they will definitely have appropriate intervention. The reason why they are providing for some level of compensation is because they don't want you to kill the animals in retaliation to whatever damage they might have caused to you. So the best is for you to report, but don't kill. Any killing of any wild animal is illegal, it's criminal, and you'll be prosecuted. You avoid that, please. That's my answer, madam.
Thank you very much, Mr. Chemongez. Let's now get the second question that was addressed to Mr. Molly. Thank you.
Thank you. The question was, when do you bring your defense to court? You bring your defense to court at a time when the court has established a prima facie case against your client. That is when an accused person is called upon to defend himself. But identification of the defense strategy, that one, you identify your strategy as early as possible. The techniques that you're going to use in favor of your client, for example, the questioning and so on and so on. But the actual defense is only brought to court when a prima facie case has been established and your client is now called upon to defend himself. And that will only be done if you have chosen or advised the client to give sworn evidence, which will subject him to cross-examination, or narrate under unsworn evidence. Still, that brings out the defense of the accused person. Thank you so much.
Thank you very much, Mr. Molly. And I think when he was talking about the time, it was in regard to the trial procedure, because as you have correctly stated, it must come at a time when he's up for defense. However, it's always wise that even during prosecution and cross-examination, the prosecution is aware that probably this is the possible defense you are to raise, and so as early as possible, insinuate, bring it up, and that's what he's talking about, the art of advocacy. So thank you very much. Unless we have another question. Do we have any other question? Okay, so we have some comments that I'm going to read out. A comment from Mr. Patrick Tenyera. He's saying, then I think all of us are guilty for the countless times we have killed rats, monkeys, squirrels, snakes, etc.
Yes, that is true.
What is your comment on that?
Patrick, as we said, as lawyers, it will be very bad for us to be ignorant of the law. I know many people don't know this, but this is the reality of our legislative system and the legal regime. We're not supposed to kill these animals. And of course, we kill them thinking it is a normal trend. We are actually having most of this species getting depleted because of that killing anyhow. So we should all be conscious and find a way of appreciating that these animals, these species, have a role that they play in our ecology. And if, for example, snakes, if the snakes were not within our ecosystem, we'll be suffering with rodents and rats and all this. They play a very big role in enabling us have a good environment. But because we don't know, we just warrantly kill them. And snakes are not animals that want to kill you. No. They know their prey, they focus on it. They will look at you and they move away. But most of the time, it is us who will chase them and kill them. And when you chase and you want to kill, that's when they turn and come for you. And otherwise, we are not their prey, and we should not focus on them. So, of course, when they become in danger, like the comment of Wamboba, Arafa is wondering what will happen if there is threat to humans. We have already mentioned earlier on that there is a defense of self-defense. If killing is in the law, you can kill if it is threatening you, and you report. There is a procedure there on what happens if you are focusing on self-defense. Otherwise, it is important for us to appreciate our legal regime and know that some of this information is key. Many people don't appreciate that any killing of any animal or any species is actually criminalized within our legislative framework. I submit, Madam Moderator. Thank you.
Thank you very much. And thank you, our audience, for your comments. I think what is highlighted is that ignorance of the law is not a defense, so it is good to be armed with the law, and then you choose to do what is right in order to protect yourself from liability. So I want to extend our sincere gratitude to the two speakers, Mr. Chemonges, the head of legal here, and is also our host here. And also want to say thank you to Mr. Molly. I'm seeing other comments that are coming up now. I wanted to close this first session and we go to the next speakers. But considering that we have a few more minutes that were allocated to this first session, I will allow Mr. Molly to quickly go through those comments before we close this first session and move on to the next. Thank you very much.
Thank you, Sylvia. What happens to submissions in respect of mitigating factors when the accused decides to remain silent? Thank you. Now, the option of remaining silent is one of the options to give a defense. And that does not stop court from convicting the accused. Okay? So when you choose to give to remain silent and court goes ahead to convict, as counsel for accused, you still have a duty to mitigate in favor of your client. You still owe the court a duty, actually your client a duty for mitigation. I want to again give another example. That I had two judicial officers in different places. One of them was a Catholic. And whenever an accused person would come with a Bible or rosary, and he informs the judge, "My Lord, I am now remorseful. You see, I'm even a leader in our ward in the prison," the guys would go home with a lenient sentence. Another one was a female judge, most of us know. As long as you would come to court, by then I was in Nakawa State Attorney, as long as the accused would come and inform court, "I am born again. I'm remorseful and born again." That alone would go into the heart of the judge. And this fellow has always got, she's now retired, Supreme Court. Okay? So as defense counsel, whether a person remained silent or not, you owe a duty to the client to mitigate as much as possible. What most judicial officers seem to be uncomfortable dismissing a case at no case to answer. What's your take on this? Now, Mr. Isaac Omara, for you, your work is to play your duty as counsel. Submit at no case to answer and let the court decide. You know, it is so funny because the case of Ramlal Bhatt says if a person chooses to remain silent and you put him on his defense, it is expected that you're going to convict. Okay? So whether the judicial officer is not happy with dismissing at no case to answer, make sure you go on record. My Lord, for me, I want to make submissions for no case to answer. Then let the court make its finding. You can even use it as a ground of appeal for the next level. But let's not assume that because the court does not want to dismiss, we should stop making submissions at no case to answer. Then we have Christian. What do you have to say about the bail guidelines superseding the law governing bail by most judicial officers? There is a tendency that bail guidelines override. Now that is a matter, it is a case-to-case basis. We have judicial officers who apply both the guidelines and the law, but you see, the law supersedes. Your work again as a counsel is to ensure that you submit appropriately. When the ruling whether the judicial officer is inclined to follow what is in the guidelines, that is none of your business. But as a counsel, if you have done your best, but what is there in the bail guidelines that cannot enable you secure bail? If they have talked of proof of exceptional circumstances, at least endeavor to. If they have talked of course, we can still proceed in the absence of exceptional circumstances. Now, for you as counsel, you must emphasize or stick to your point that, my Lord, we are sticking to provisions. Supposing it's High Court, Section 15, TIA as it then was, I've not read the current revision, and you emphasize, then let the court make its finding, but for you as counsel, you have emphasized the fact that you address your mind both to the law and the statute and the guidelines. Thank you.
Thank you very much, Mr. Molly. I'm seeing one last comment from Joshua, and I request that Mr. Chemonges just takes through that as the last question before we close this session.
Thank you, Madam Moderator. Joshua says, how do we deal with the issue of political interference vis-a-vis conservation? We have seen instances, for example, currently with Murchison Falls, where MPs are demanding unlimited access to the park regardless of the park rules. Isn't this a challenge to UWA? Yes, this is a very big challenge to UWA, and not only in Murchison Falls. We are having a big challenge of political and the other interferences in terms of conservation. Politicians in most of the parts of the country promise people land from these protected areas as they campaign, and that is a big challenge. And we are having encroachment to these protected resources of the government and the people of Uganda, instigated by politicians. It's a big challenge that we face at local level, at national level, and in all places. We have a reserve called East Mad Wildlife Reserve, which is now a subject of contestation between the people of Adjumani and Amuru, and the political, it is suffering. Ordinarily, you will not mind whether the reserve is in Amuru or Adjumani, as long as the reserve, you protect it. But the people are fighting for it, and the politicians from both sides failing people to disseminate this protected area. We have, of course, hostilities in some of the areas where our rangers operate, where communities mobilize people and take them to the park, and the real fights are there. So this is a big challenge that we have, and how do we deal with it? We have continued to engage with politicians as well at different levels. Through our political leadership, the Ministry of Tourism, Wildlife and Antiquities, to engage. Now, specifically the issue of Murchison, that one came as an issue that resulted from the closure of Karuma. When Karuma Bridge was closed, the people of West Nile and Northern Uganda needed alternative routes to reach that part of the country. And so, whereas the Ministry of Tourism, working with Ministry of Works, came up with a regulated use of Murchison Falls. There's 3 routes within Murchison Falls, and they created different traffic using different routes. One route for heavy traffic, like trucks and trailers and the lorries. Another route for buses, minibuses and small cars, and another route for tourism, for tourists. Of course, the politicians from parts of the north were opposed to this for several reasons that they had. But following harmonization from the office of the president, there were guidelines that were issued and adjustments were made, and we are working with them well to ensure that people are able to transit. Of course, we're still having challenges. The routes that had been given earlier on were calculated based on the level of inconvenience to the traffickers, but also inconvenience to wildlife. But the adjustments, of course, have also resulted into some level of loss, because there is quite road kills. Several animals are dying on the road because of some of these decisions. But that's definitely resulting from the politics, which sometimes become inevitable. Like in this instance of Murchison, it is quite a difficult one. We are just hoping and praying that the Ministry of Works, working with UNRA, are able to quickly fix Karuma Bridge, and then we divert back the traffic and avoid the impacts that we are having through Murchison Falls. As a country, definitely we are losing wildlife. We are having a lot of pollution in this ecosystem. Of course, accidents are also happening. People are dying along the road. Just imagine a bus hitting an elephant, and of course, the elephant is as heavy. and you find that people are dying in these parks. And we hope that we are able to fix this. Otherwise, we want to implore on all of you. On this forum, I see there are many politicians. Let us use the politics in a way that develops the country, not destroying the country. I submit.
Thank you very much. I think we have come to the end of this session. Join with me as we appreciate our speakers, Mr. Molly Albert and Mr. Chemongez, for that very elaborate and insightful and rich presentations that they made earlier. Thank you so much. We will now move on to the next session. The next session, we have the first speaker for the next session, who is Mr. Kamba Hassan. He's going to be presenting the topic of challenges in recording and reliance on confessions in criminal trials. Challenges in recording and reliance on confession in criminal trials. Mr. Kamba Hassan has an LLM from IPSK, an LLB from Makerere University, and a diploma from Law Development Center. He has a certificate in mediation from UAE. He's a partner with Kamba and Balondemo Advocates. He's an associate with Prax Lex Advocates. He's formerly a professional associate with associate lecturer with Law Development Center. I know he's senior, and he will tell us how many years he has been in practice. So, Mr. Kamba, you're most welcome to give justice to this topic. Thank you very much.
Thank you very much, Madam Moderator, for the invitation and beautiful introduction. I am now making, next year will be my 21st year in practice, and I'm still good to go. I'm happy also to say that Mr. Molly Albert is my classmate at Law Development Center, although now he's a head criminal, if I'm not mistaken, at the center. Today we are handling a very obvious topic to most of you, but which raises a lot of subtle and intricate challenges, whereby prosecutors, at least for them, they know what to do, but for defense counsel especially, it might be an uphill task to undertake to challenge confessions. I will not go into definitions, and I will not speak the obvious. I will not speak what you studied at law school and at LDC, what is a confession, section 24, 23, 24, 25, and the 29A of the Evidence Act, formerly Cap 6, now Cap 8. And I'll be hitting the bull by the eye. Many cases, Madam Moderator, have not been or could not be successfully prosecuted, could not have been successfully prosecuted without a confession. And you know very many recent ones. Some, the victims are in Ruzira, either by confessions made by themselves or confessions by accomplices. So, a good example is Kajubi, the most prominent ones, which succeeded on a confession by an accomplice who later turned into a state witness. Uganda versus Ponciano Rwakataka was supposed to proceed on a confession. Unfortunately, the accomplice was convicted and sentenced to life before he could come to testify, which angered him. And I was in that case. So when he came to Masaka, he said, I don't know even where the scene of crime was. I was actually in prison. And somewhere else, but had been promised A, B, and C. So as to confess, this makes the subject very timely and relevant for us, and mostly in these environmental cases and utilities cases. I think 99.5% of convictions are based on confessions. Somebody is put in prison or in cells, police cells for some time, and he has to heed to pressure, and he confesses. It would be difficult sometimes to investigate or develop other evidence sufficient to convict, and thus the investigators and the police generally, and maybe OR investigators and National Bureau of Standard investigators and other utilities investigators are always eager to hear anything in the sound of a confession. Responding to this pressure to reliably elicit confessions from their suspects, some may think that the police have developed sophisticated psychological techniques to accomplish two goals. One, to induce suspects to submit to questioning without an attorney. That's why, as my colleagues will agree, most of the time when witnesses are making statements, strangely you will be chased out of the room. And two, to induce them to confess. Unfortunately, these methods, if used, are sufficiently powerful and highly studied to induce false as well as true confessions and render them voluntary or involuntary. Because they are based often on subtle yet sophisticated means of influence, their coercive power sometimes goes unrecognized, and the conviction is scored by those who must judge their voluntariness or validity. This yields a crucially important, yet often an unrecognized three-pronged problem with confession evidence. That is voluntariness, validity, and prejudicial impact as barriers to recognizing the problem. Modern psychology interrogation techniques such as deception. If you confess, if you say this, you will get this, like in the Uganda versus Rwakataka case. A3 Mudu Asumani was promised a house in the village and so forth because they were targeting the big fish. Ingratiation, promises, and threats are key and very important techniques used by those extracting the confessions. But first of all, confessions are of two types. And one, confession is made before arrest, and confession is made after arrest. Can a confession be made to an LC1 or a chief, or to those who respond to the alarm? Is it admissible? Is it not admissible? That was considered in the decision of Babiebu Zaswaib versus Uganda where criminal appeal number 47 of 2000, where the Supreme Court dealt with the matter at length and held that where a confession is made to a person in authority, that is before arrest, such as a chief or an eros official, that may be taken into consideration in determining whether it was a voluntary statement for purposes of Section 25 of the Evidence Act, which was quoted in extenso in that decision. The interrogation now at arrest level begins with an invitation, either an invitation to police or being tracked down and arrested It proceeds to the accusatory stage with the two messages. We know you did this. We have sufficient evidence to convict you. No hope of exoneration. But to minimize the consequences, the urge to confess falsely is always by force or enticement or serious psychological arbitration. Richard J. Ofsh and Richard A. Leo, the decision to confess falsely, rational choice and irrational action, have written. In other words, the interrogation is cast as a negotiation in which the interrogator has both the carrot and stick. And these are things which both the state attorneys looking out to sanction charges based on confessions should look out, and has the authority to determine what will happen to the presumably surrendered suspect. Now, problems, there are so many problems. Some of them are well known, but I will first go step by step. Before the prosecution can use a statement in evidence against an accused person who objects to it being put in evidence, you know the first hurdle is that the trial judge has to decide whether to allow the prosecution to tender in the confession statement and to determine whether it is admissible in evidence or not. And in order to admit the confession has to pass to what now the UK decisions and courts call the reliability test, and what now we call here the voluntariness test. And the UK has abandoned, and the European courts such as the New South Wales and the UK have abandoned that voluntariness because of now the psychological methods available to extract information by way of threats. There was, I had a client called Kato who had been in custody in one of the agencies' custody for 6 months. And he said, now you have been here for a very long time. Can you rush before magistrate and accept so that we see what to do? So the court, in order to admit the confession has to pass the reliability test, that is, whether the statement was made voluntarily. That question is decided after hearing evidence from witnesses about circumstances in which the accused made the confession. That is what we call a trial within a trial. This can lead to enormous time taken or delay taken in concluding the prosecution of the case. In Ibrahim versus Ara, this is a 1914 appeal cases case, 1914 square brackets SC 559 at 609, Lord Summer defined the concept of voluntariness as follows. So, one of the things you must face is to prove voluntariness at the trial. both at the charging point and at the trial, because the state attorney must satisfy himself or herself that actually for the trial to succeed on confessions, there must be two things. There must be evidence to corroborate the confession, and the confession itself must have been secured voluntarily, as we shall come to see. No statement, that is Rodi Sama, in that case I've cited above, page 559 at page 609, Ibrahim versus Ara, 1914 SC. He held that no statement by the accused is admissible against him or her unless it is shown by the prosecution to have been a voluntary statement, in the sense that it has not been obtained from him either by fear, mere fear of prejudice, or hope of advantage exercised or held out by a person in authority. Again, I will refer you to that criminal case decision of Uganda, of Babyebuza Swaib versus Uganda, and several others reported in the East African law reports. But what constitutes voluntariness? What constitutes voluntariness has been has raised a lot of ground with the differing decisions on the point. Others say that once evidence is adduced, it entails several things which the prosecution and the defense counsel must look out for, which I am going to talk about after making the next point. Even where a confession is voluntarily made, the prosecution faces another hurdle. A trial judge has discretionary power to refuse to admit the confession if, in his or her opinion, it would be unfair to administer it in light of all the material circumstances and all the evidence before him or her. In that case of Ara versus Sang, 1980 SC 402, at pages 434 to 435, Lord Diprok held that there has now developed a general rule of practice whereby a trial court has discretion to exclude evidence, though technically admissible, where it would probably have a prejudicial influence on the minds, use the jury, but insert assessors, in the minds of the jury, to bracket assessors, which would be out of proportion to its evidential value. See also Nyota versus Uganda. You will find that most confessions, once an accused person pleads that he was tortured, it can kill the entire trial, like in Nyota versus Uganda, and now the pending decision, a constitutional reference of Wakamba versus Attorney General, Nyota versus Attorney General. Under Section 8 of the Human Rights Enforcement Act, where a question is raised as to the violation of human rights of an accused person, the trial must first stop, and that question should be determined first. So you might find that in one trial, if issues of human rights are raised, you might have a trial within a trial and another trial to determine on application whether human rights of the accused person. You know, when Akamba, this MP, Akamba Paul, was arrested in a very glaringly in open camera, in a very rough and torturous manner. We were handling that decision of Mutembuli Yusuf, Uganda versus Mutembuli Yusuf and others, and we were ready to cross-examine the chairperson, Human Rights Commission, when unfortunately Council Mukama is called who? Council Mugisha Kibe Bia Mukama threw in a Jude, threw in a spanner. We were ready with the Arakas, ready to assault, but then an application came even when the prosecution had laid evidence and allegations that there was a human rights violation. So, where a confession is extracted via torture, to be plainly, it can lead to several trial and pre-trial questions arising thereof. Thus, because of that, but in Uganda, the exclusionary rule is not prominently. This one I've cited of Rod Diprok in Ara versus Sang. The exclusionary rule is not very prominent, although some judges still apply it, but in a very weak manner. But because of that, the UK and other jurisdictions like South Africa and even Kenya here, our neighbors, they have had a shift from the voluntariness test to now the reliability. And the spanner now has been brought in with the now video recordings. Confessions are being recorded. Tape recorded, and now there is a second aspect that he confessed, and his video of the confession is here, and admission. Even in that case, there is a ruling by Justice Gidudu in Mutembu Youth Fund and other, in Uganda versus Mutembu Youth Fund others, in which Justice Gidudu said that the only test where an admission or a confession is in a recording is the reliability test. Now we go to the Electronic Transactions Act, sections 7 and 8, 5, 6, 7 and 8, which says that once the reliability test is passed, is it reliable? And so forth. So Atara versus Sang. So I was saying that they have abandoned the voluntariness test, and now is the confession reliable? Yes, he might have made the confession. Yes, it might be technically true that he made the confession, but is it reliable? And I will give the tests to follow in determining the reliability. But you can read cases such as DPP versus Pinglin, 1976 SC 574, and also Section 29A of the Evidence Act. The other problem, major problem, is that the people recording confessions sometimes are very eager. That like in the case of Namurobi Hasid versus Uganda, that is made it right up here. Namurobi versus Uganda, and reported criminal case number 16 of 1997, determined on 13th July 1998. It is in that article by Robert Doyer Nanina, the South African, I think, professor. The confession was rejected because it was improperly obtained. So the problem of improperly obtained confessions. The improprieties included the fact that the accused person did not sign the confession. Very small omissions. And there was an insertion of a name of a detective on the confession. It was made by a sergeant. Then when they realized that the section requires that a person of the rank above Inspector of Police, Mainja Abiri, must have recorded, then they inserted the name. So there were two names now. You get the point. 2 names, the person who made the statement, then they added the one of the inspector. Of course, those are hurdles. The name of the detective on the confession, and that the confession was recorded in a room full of other police officers and the people doing other work. Now, the prosecutors and the defense now need to pay serious attention, and the police generally, that when recording a confession, it must be in a secluded room. The name, first it must be made in the language of the person, or an interpreter must be present, and an interpreter must also make a statement. Now, there was a time when all detectives were either Ateso or from northern Uganda. From the English they used to talk. And most confessions collapsed there between 1997 and early 2006, when they started to do what? To wake up. When you read those judgments, 1989 to 1990 East African Road Reports, those HCBs up to 208, you will find very many confessions collapsing on very flimsy and obvious points, such as 1, the statement must be made in the language which the accused person understands. I have never seen a statement in any vernacular language. And even if you are a very good expert, or in a language, unless you studied it up to Makerere or to A level, making a statement even in the languages I speak, Rusoga, Rugiswa, and Rusamia, it is very difficult. You get the point. But now they softened and said, at least it must be proved that an interpreter must have been around. So to prove this, what the police does now is to bring a video recording, and you make, which raises another question now of reliability and relevance. You get the point. So in that case of Namurobi Hassad versus Uganda, criminal case number 16 of 1997, I think it went up to appeal. Even mere making a confession in a room where there are other persons. But imagine our police stations now. I don't know of any police station with a separate room for confessions. And even magistrates now are skeptical, except these days. Previously, in I think 1998, Arinaitwe was taken before the magistrate, just His Worship Aluvisa, now Justice Aluvisa, for a confession. And instead, the man was a serial killer. He jumped on the neck of the magistrate. Lucky enough that she has risen through the ranks, and we pray that she rises up to the Supreme Court, because she is a living testimony. She's a living testimony of dangers. The court recognized in that case the fact that the police do not usually have enough room for a recording officer to be alone with an accused, and that the appellant never complained about the irregularity in the mode of recording the confession. And he said that also further held that although the confession was recorded in a language the appellant did not understand, the fact that it was read back to him was proof that he voluntarily made it. Of course, I have problems with this decision. What if they read back the confession to me in English, and I don't know English, and they say, we are going to read for you, tugenda kusomera ulira, then they read in English. So the court should have gone further to elaborate on that principle. But there are also rules. In that case, there was a complaint to court that the recording of the confession was not done in accordance with the evidence into bracket statements to police officers rules. I think this one lawyers have not come into contact with them seriously, like the CJ's guidelines on confessions. I think Mr. Moli, now you need to train lawyers seriously on these things. I think after I'll send you my paper on email. I'll send it to URS and you might get it. That the confession was not made in accordance with the evidence into bracket statements to police officers rules herein, which I will refer to as the rules regarding the procedure of recording confessions, especially rule 4 of those rules. But the court recognized that the Evidence Amendment Decree 25 of 1971 did repeal those rules, although on further appeal, the rules were relied upon. But now I think with the CJ guidelines and the Evidence Act Cap 80 now, those rules might not be other than, and with the police standing orders, generally with available police standing orders, which incorporated those rules on how statements are made and Evidence Act. The second case I want to point on, which also brings out other aspects which are not obvious to the naked eye, is the case of Sewankambo Francis and Sewankambo Francis and others versus Uganda. It is criminal case appeal number 33 of 201, 28th February 2003, where the appellants appealed to the Supreme Court, claiming that the Court of Appeal erred in law when it admitted their retracted confessions. They contended that the confessions were recorded by the same investigating officers, which was an irregularity. The IO, again the same person recording what? The confessions, because now the IO wants his case to do what? To succeed. In addition, in the course of admitting the confession, the trial judge did not inquire from the defense as to whether it had an objection to the admission and just admitted it. The court agreed with the appearance, the Supreme Court agreed with the appearance, and held that it was improper to admit the confessions because the trial judge did not give the defense an opportunity to say anything about the nature of the confessions before they were admitted. Now the question, what if you have an indolent lawyer, like the one in Criminal Appeal number 50 of 1998, where the court of course held that a poor lawyer is a ground of appeal, Kawoya. Kawoya versus Uganda, Kawoya Joseph versus Uganda. And they admitting the document and the lawyer, because the judge has not asked, and sometimes the judge wait for you to raise. If you don't, they just admit. What would happen? That is a serious question. Two serious questions to note here, which I've so far talked about: the police standing orders and how police should make statements, the Evidence Act, and confessions made before arrests. How do you treat them? Challenges. The High Court did not, the Supreme Court further held that the High Court did not subject the admissibility of the confession to a trial within a trial to test the voluntariness of the recording of the confessions. again, that is another issue. I have said language barrier has been previously has been a very big issue, and very many cases have been lost on that aspect alone. That most of our detectives were either from Teso or from the north, from the language they used to talk. Eh? My friend, hey. So now, the question, if I don't know the language, even if there is an IP, inspector of police, at the police, who is supposed to record the confession, what happens? Then the best thing, you take two options. To take to the magistrate, where an interpreter will be brought in to help to interpret to the accused person everything that is said, that may be, but may pass the test of reliability. Because you can say, those serial killers or those who used to strangle people in cars, those car thieves, I think you remember their trial. They were retracting their statement. He will say, no, you didn't read for me. How do you prove? And unlike these days where now video and audio electronic evidence is acceptable. So these are serious and critical elements. Which language do you register it? Is it signed? Most times there was one before magistrate where even again the accused was not given a chance. The magistrate just wrote the confession and signed and said, he was recording. Have you understood? Confirm that the state, what you have said has been interpreted to you? Yes. And there was a confession. The other case is the case of Nashaba Pade versus Uganda. Nashaba Pade versus Uganda is criminal appeal number 39 of 2002 square brackets Uganda Supreme Court, page 17. It was decided on 15th April 2002. In that case, the appellant and three others were involved in the commission of a robbery. When the appellant was arrested, he gave incriminating information to an inspector of police about himself and the two other persons in the commission of the crime. After police had recovered the evidence on the basis of information given, the appellant was taken to a magistrate, where he recorded an extrajudicial statement. On appeal, the appellant claimed that the confession should not have been admitted because of the irregularities and human rights violations in the recording of the statement. In reference to irregularities, it was contended that the appellant was not informed of the charges against him before the magistrate. Now that one. That the statement was not recorded in the language that the appellant spoke, and that the holding that the confession of the appellant was obtained voluntarily was not supported by evidence. The court showed a willingness to admit a statement if the impropriety was not a material departure from the rules. The courts are always prepared to admit a statement if the impropriety was not of the confession is not a material departure from the rules of recording the statement. And the court stated that although the honorable mission of the magistrate in not certifying the charge and caution statement, it was cured by confirmation by the appellant that the recording was accurate. The court further held that the Chief Justice's rules, which now everybody on recording confessions, were rules of practice and not law. And not law, and as such, a contravention thereof would not render recording to be bad if the confession is those rules which provide that it must be in this language. The magistrate must sign the charge and caution. The court made a very clear statement that even if there were problems with the confession, once the court found that it was made voluntarily, even if you say it was not made in my language, it was not written in my language, my rights to be informed of the charges, but once the court establishes that the court was made voluntarily and is reliable, the confession will have to do what? Will have to stand. I will end with the decision again of the Supreme Court in Mweru Ali and others versus Uganda. Mweru Ali and others versus Uganda. Mweru Ali and others versus Uganda, where the appearance were charged with robbery and convicted on the basis of confessions made by the first and second appearance. They appealed on the grounds that the confessions had been repudiated. Now, repudiation is another challenge. It was established the court downplayed the failure to follow the rules of recording confessions, since it found that the failure to test the one confession in a trial within a trial, or to record the other confession in the language of the apparent, were not fatal to the appearance because the confessions were corroborated. The confession must be made according to those CJ guidelines, but now they were downplayed by the Supreme Court itself. And now on the panel, the CJ was not there, yet the rules were made by the CJ. So in a nutshell, the major challenges now is that we are seeing more confessions than before. Why? Because of reasons you best know. Psychological torture, physical. Utaongea, you will speak. You get the point. And also prejudice. If you don't do this, this will happen. Why? And yet the courts have interchangeably either rejected or allowed them. Now, with the decision of the Supreme Court, I have referred to, and where the Supreme Court held that even if a confession does not follow those guidelines, but it is established that the confession was voluntarily made, then the confession must stand. But that must be taken in line with the new Human Rights Act 2019, the Human Rights Enforcement Act, I think 2019, if I'm not mistaken, which now makes any trial illegal for violation of the human rights of the accused person. So these are things we must guard out for when admitting, when recording and admitting confessions, and which the statement. You should read the CJ guidelines on confessions seriously, and I'm sure I didn't read the sections verbatim because I know these were studied at university and elaborated at RDC. Thank you, Madam Moderator.
Thank you very much, Mr. Kamba, for that very insightful presentation. It's been very rich, and I think this is a very key area for criminal practitioners. As you have noted very clearly, we have an increase of evidence of confessions, and sometimes it's the biggest evidence that prosecution has. Sometimes in some trials, it's the only evidence on file that without it, prosecution can actually not hold their case. So it's very important for defense counsel to be armed with how to deal with confessions and how to defend your client if they should tell you, well, that was a confession that was procured illegally for some reason or another. It's very important. Thank you so much. I want to remind our listeners, the people online, that we're going to have a question and answer session and comments after the next speaker. So if you have any questions for Mr. Kamba, please put them in the comment section, or you raise your hand when we ask for questions. So it's important that you utilize the resource that is before us, so that whatever clarifications you may need addressed here, while we still have him here. But thank you so much for that elaborate presentation. Mr. Kamba was discussing the challenges in recording and reliance on confession in criminal trials. And our next speaker is going to talk about the admissibility and authenticity of electronic evidence. And this was meant to be presented by Mr. Kale Balaka. Unfortunately, Mr. Kale Balaka could not be with us for reason of bereavement. He was suddenly called away. And so we're going to get Counsel Molly Albert to stand in for Mr. Kale Balaka, discussing the admissibility and authenticity of electronic evidence. I believe that his discussion will also enrich what Mr. Kamba has just discussed concerning the confession, because the two discussions or the two presentations are intertwined, and that's why we have decided that the question and answer session will come after the two presentations. Mr. Kamba, before you make leave of this place here, many times as defense counsel, we find ourselves with situations where a client is talking about the fact that they were tortured, as you have given those examples. They were tortured, this evidence was procured, the charge and caution statement have been procured illegally. However, the courts are asking for evidence. Give evidence that you were tortured. This is 4 years later. Everything has healed. Sometimes there are barely any scars. There's no picture before and after for you to be able to say yes. So how do you deal with situations like that?
Yeah, as I said, Section 8 of the Human Rights Enforcement Act brings in a solution. In that case, even before the trial, but if the trial is on and you want to challenge on account of torture, you must file an application. Evidence is not only in the form of photographs, or if you have scars, well and good, but you could have medical reports made. If you are in incarceration, they could apply to court to have you subjected to a private medical practitioner to examine you. But normally the evidence, torture is not only physical, it could be psychological. That's why you must, the application is by notice of motion, normally, where you detail and how you were tortured, by who, and the Attorney General is always given room to reply to your allegations in the specific trial, and the court determines that on a balance of probabilities. Both the trial within a trial, to determine the voluntariness of the confession, and the trial within a trial to determine whether their human rights must be based on application. And the Court of Appeal luckily has laid very good guidance and has said it need not be in Nyota versus Uganda. It said, it laid back, it said, torture need not be that you present scars, that you must do this. It has held this at least, and held that once in the mind of the judge, it is probable, more probable than not, that you were tortured, being guided by principles of evidence, of the weight attached to evidence, then you can succeed. But even if relatives came to see you when you are still sitting on your stomach, sometimes they can give you a bloody nose and you cannot even sit. They can also put in affidavit evidence and some other persons, and it is not difficult to prove according to that decision.
Okay, thank you very much, Mr. Kamba. We really appreciate the time that you have taken off to be with us here, and for that very rich and insightful presentation that you have made. I'm sure that our listeners, the people online, have been blessed by that. Like I stated before, that there's going to be a time for questions and comments after our next speaker, and the questions will be directed to both presenters. So I request that you put in the questions in our Q&A column, or at the time you can raise your hand when we call in for questions to be able to raise a question to both Mr. Kamba and our next speaker. So as I was stating earlier, that our next presentation was supposed to be made by Mr. Alaka, who unfortunately could not be with us on reason of bereavement. And we had to call in another criminology guru who could come and take his place at such short notice. And that is Mr. Molly Albert. Oh. I'm being advised that Mr. Kamba is going away very briefly. So do we have any questions? Do we have any questions or comments that we can put to Mr. Kamba before he excuses himself? We could project the... So, Mr. Kamba, I welcome you to take on the questions that you're seeing there that are projected in the Q&A section and answer them. Okay, I'll read them out to you. What happens to submissions in respect of mitigating factors? Oh, okay. Oh. Oh, it looks like we don't have any. Do we have any other comments or any other questions that can be addressed to Mr. Kamba in respect to his presentation? If somebody has a question, you could raise your hand. Mr. Kamba, I see somebody. Mr. Basalirwa Osman is appreciating your presentation.
Thank you, Honorable. You used to be my partner, but you, you disappeared in oblivion.
So if somebody has a question, you could raise your hand before we discharge Mr. Kamba. He has to leave us now before we move on to the next presentation. I think we don't have any questions. So, Mr. Kamba, thank you so much. Thank you so much for your presentation. We are receiving thanks from somebody else. Thank you for the presentation. So we'll excuse Mr. Kamba, and then we'll invite our next presenter, Mr. Albert Molly. He was gracious to come in to take on Mr. Alaka's presentation at such a short notice. Mr. Molly will be discussing the admissibility and authenticity of electronic evidence. And he was previously introduced, so I will invite him to just take on his seat and continue with the presentation. You're welcome, Mr. Molly.
Thank you, Sylvia, for the moderation, and I want to thank the colleagues online for the patience and the urge to learn and share experiences. I've always said learning never ends. It's a day-to-day process. Each other day we get to learn something new to better ourselves. For those that were not here in the morning and have not had the benefit of interacting with me before, Molly Albert Sibuta is my name. I am a head of subject at Law Development Center. My niche is criminal proceedings and trial advocacy at LDC. But I also do private practice, mainly anti-corruption court, and the latest, I think for the last 4 years, Supreme Court. So you rarely see me in High Court and the lower courts unless strictly instructed on a private brief. I've been requested to deal with something that falls within the docket of my subject on short notice, and I believe I'll be of help to you in the course of our session. Admissibility of electronic evidence in the criminal justice. We start by appreciating what electronic evidence is. And we have to say that electronic evidence is associated with the use of digital devices in commission or omission of crimes. Okay, use of digital devices in commission or omission of crimes. And most times it involves manipulation, storage, and communication using computer systems. Communication, manipulation, and storage of data or information using computer systems. Now, where do we find most of this electronic evidence? You're going to find it in digital devices like computers as the first bit. We have phones. We have ATM machines, very common in money laundering and electronic fraud. We have chips and other electronic gears. Just think of any other gears that we may use for purposes of information storage or collection. In one case, I think one of my first cases in anti-corruption court, where IGG does the recording for solicitation. If they are charging you with the solicitation, it is important that there is a recording. I remember a case of Lilian Nandaula versus Uganda, the appeal. Justice Mugamba overturned the decision of the lower court just because there was no recording to confirm that there was solicitation. That is one of them. So, the devices matter. I know IGG has devices which are like pens, but what is most important is what does the device entail and what is its purpose. But also how does it operate, how is it operated, and by who. Okay? So electronic evidence falls under the category of circumstantial evidence. So it is not direct in its way. We are looking at conduct or action of someone that resulted into either commission or omission. Or you may as well use electronic evidence in defense. Okay, so that is circumstantial evidence. And we know the rules for admissibility of circumstantial evidence, that the hypothesis of guilt need not point at any other person than the accused person. If that is not met, then a conviction should not lie. What law guides us in admissibility of electronic evidence? One, we start with the Evidence Act. Then we have the Electronic Transactions Act. We have Computer Misuse Act. We have Electronic Signatures Act, among others. By the core are those four: Evidence Act, Electronic Transactions Act, Computer Misuse Act, and Electronic Signatures Act. Previously, we used to say 2010, but now under revision, we get them in the revised laws by Law Reform Commission. So, the issue is admissibility. What does the court consider, or what falls at the back of your mind if, assuming the prosecution is bringing such evidence or intends to rely on such evidence and your defense counsel? What should be at the back of your mind before you let this pass as admissible? We have been guided in the case of Uganda versus Serunkuma and others. It's High Court Criminal Session number 15 of 2013, where court emphasizes the aspect of authenticity and reliability of the gadgets before such evidence can be admitted. So what is authenticity as one that the court is going to look at? The question here is, has the system, has the information been tampered with in any way or not? So such gadget or information should not have been manipulated. It should not have been altered. It should not have been, for instance, updated. It should not have been deleted, any part of it. Authenticity. In some cases, the courts emphasize that after generating such information, the person who operated the gadget must certify, make a certificate of authentication to certify that the gadget was in good use, and I confirm that the information therein is authentic and in its original form. Then he signs. That is the authenticity bit. But the other bit that the court is looking at is reliability. Okay? So court presumes that the device was in good order at the time when the recording was made. Was the machine or the gadget in operational state or not? Now, I had a matter, again, where IGG gave a gadget to a witness, complainant, to go and record someone still in the police station. Now, this fella reached the venue, and instead of pressing the button of play, he pressed pause. Okay? Now, at the end of the day, he did not record anything. The thing was in order, in good shape, but he did not do what they wanted. So we come to court. When the IO was testifying, said, you see, the complainant came, we gave him money, we gave him a damper recorder to go and record. Now when he came back, we told you, we tried it, he handed back. Then when we tried to play, there was nothing recorded. When we asked him, which button did you press? He showed us the middle one, which is pause, instead of the third one, which is for playing and record, then the last one for stopping. Okay? So actually, this fellow was acquitted on that basis. Although the witness orally confirmed that there was solicitation, but there needed to be corroborating circumstantial evidence. Now, in this case, they had failed to secure the relevant evidence, and the person is acquitted. So, reliability. Was the computer working properly, or was the device working properly? If it is one which is on and off, and the recording is in bits or patches, again, it raises a lot of doubt in the mind of court. So as a defense, I can also not accept such information or evidence to be admitted in evidence. Okay? So usually reliability and authenticity are very key when you're dealing with electronic evidence. Now, where do we get jurisprudence in as far as admissibility of electronic evidence is concerned? We have very old laws, especially East African Court of Appeal, then we come to Uganda, and then finally, this is settled in the case of Amongini Jane Francis. I think Amongini Jane Francis Okiri versus Lucy Akero. The Lucy Akero and Electoral Commission. It was an election petition where electronic evidence was supposed to be tendered in, and counsel for the respondent says no, I have an objection. Then finally the court sets down guidelines that before such evidence is admitted, the following should be considered. Okay? One, again, was the reliability of the equipment. Was it in functional condition that the information gathered can successfully be relied upon for evidential purposes? Then two, the manner in which the basic data is stored. If the gadget was working, information is collected. How is it stored? Do you leave the computer still open and accessible? Actually, in cross-exam, we always ask that. Where was this thing, information kept after you received or recorded? It's very key. The measure taken to ensure accuracy of data entered. Accuracy of data entered. Is it the very one? Did you record the necessary? You know, I can talk 100 words, yet you only want 2 for evidential purposes. Okay? The accuracy in recording the information that is necessary, very key. If it's a video recording and your focus, for instance, has diverted from the presenter and you're recording the participants, and then you come and say, no, Molly Albert made a presentation and there is little to do with the presenter but more focus on the audience, then that raises questions. Okay? Then item 4 or consideration number 4 is the method of storing the data and precautions taken to prevent loss or alteration. The method of storage and precaution to avoid loss or alteration. It is advisable that after the general recording, this information is picked and is stored. Either nowadays we are using flash disks. Okay? We used to have compact disks, and as we are developing, we keep advancing. Actually, nowadays we are both IG and DPP. When they are disclosing the electronic information, the latest they have been giving us flash disks. Yes, flashes. They will disclose the whole file with all the policy statements, and then on top of that, they hand you a disk, a flash. Then that means when I get to office, I must play that flash and see the nature of information that prosecution is intending to rely on against my client. And I do that in the presence of the client and see how we prepare, again, going back to the first presentation, what to attack and what to leave out. Okay? I have a situation where it's an ongoing case, but the complainant had cameras at the store. It is a warehouse where there is alleged theft and so on. So my client says there are cameras. So I expect what? Footages to be exhibited. But when disclosure was made, there was nothing like footages. Then when I was asking the security fellas, other than you alleging orally, what evidence do you have to show that this man ever set his feet in your compound? Confirm, isn't it true that you have cameras? Yes. The man says, no, you see that day we had not switched them on. We had not. And I think, anyway, I cannot talk much because we are still battling. But precaution, storage and precaution. So when you pick from a flash, seal it in an envelope or seal it in the exhibit bag. We call it exhibit store bag. Have it kept in a secure place until that time when it's required for court action. Not just a matter of leaving the information on the general computer which any other person can access. Some of us keep this information, and when we reach home, the gadgets are accessed by our children. So any slight tampering on the gadget or information is sufficient to make such information or evidence inadmissible. Among in this case also calls for consideration of the measures taken to verify the accuracy of the program used. Which program was used and is it accurate? Now there, the ICT experts know the different programs. Did you store it in Excel, in what, whichever method or program that you applied, you must disclose that to court. Then, what software was used to preserve digital evidence in its original form and to authenticate it? Again, software used. Very important. Then come next is competency of the person who accessed the original data. The person who did the original recording, was he competent? I gave you the case of that fella who failed to play the gadget. Meaning he was not competent. Instead of pressing play button, he pressed a pause and thought he's recording. And indeed, this was a broke man from where? Because he had come for bail in LDC court and they demanded for some money, these clerks. And so a villager, I think from Bukoma Simbi, trying to secure release of his son, they give him 200,000 at IG to cause an arrest. You have not taken the person through training of how to use the gadget. And now those are actually these areas that are highlighted or listed in among in his case are areas that Defense Counsel always focuses on for purposes of cross-examination. Okay? I'm going to read 3-4 times before I come to court. And among them is the competency of the person who operated or accessed the original data. That is to say, the person must be in a position to give evidence explaining the relevance and implication of what he did. Now, does this man know all that? No. So if he doesn't, obviously such evidence will not be admissible. Then, the last criteria that we use or court uses is, can an independent third party be able to examine the processes and achieve the same results? If we said, I was not there, but this is what ought to have been done, other than you yourself, can another person access this information the way you did? That means there is no monopoly. Otherwise, you might complicate putting passwords that are complicating things that no other person can access such information or can do this. No, the law is asking, can a third party be in a position to examine the process? If yes, then it's okay to achieve the same results. You don't have any monopoly over the gadget or the system. Remember, it involved programs and software among others. So if I got another ICT expert, is he in a position to do it? Now, competency. You have many people who are trying to become computer literate. But the question is, are they in position to operate all gadgets? Okay? Recently, we had a document sent, simple thing. Document was sent in PDF, we are supposed to print. Then, when we tried to download to print, it jammed. We even called 2 guys from our ICT department, they failed. And then a 3rd colleague just said, you know what? Just command print without downloading. And when we did that, we got what we wanted. And when we called the sender, he said, you see, there is some encryption that I put in because I wanted to preserve that information. So when he came, now you open the thing. He even failed himself. But good enough, one of the colleagues, who I think by it was just a grace of God that for him he said, let me just command print without these usuals of download and so on. And it did what? Work out. Okay? So the aspect of competency, the person aspect of 3rd-party ability to do the same is very key. Otherwise, such information may not be considered admissible. Okay? So those are the rules that court has guided in Amongini Jane Francis Okili versus Lucy Akero, which has been reproduced in other subsequent decisions. So practically, you have this information. How does it come to pass from the gadget or the device to become evidence? Do you record and leave it in office? That's one. Do you record and just carry the computer and bring the whole computer to court? I don't know. Do you record and we say the storage and preservation? So we have stored it on a flash. Okay? Do I just carry this flash and bring to court? My lord, the information is on this flash. Is that all? Obviously not. So what is required is whenever you have such information, electronic, you must apply to court or inform court that the next witness is an expert who recorded the occasion or occurrence, and we intend to play the recording in open court. So if the court doesn't have the relevant equipment, you tell them to look around. I remember there is a time when Uganda Road didn't have electronic gadgets, and we would cross to High Court and use the computers, screens at High Court, until finally Uganda Road secured one, I think courtroom 4, where there is one. Then now you can comfortably go to Kaizi and tell him, your worship, we have to play this information. Okay? So, step 1, inform court of the necessary evidence that you intend to rely on or to produce, which must be through the witness who recorded. Then when the witness comes to court, we have the gadget being played, or produce the device, because he is going to first take oath and we do the preliminaries. What did you do? Who are you? I am a police officer attached to ICT, qualifications, ICT masters, experience, etc. What do you know in relation to this case? He said, I recorded information and I stored it. Where was it? The incident, maybe it was a road traffic accident, or this theft, or this murder where they recorded a vehicle taking Chinawataka Road. This, I think, is the current ongoing case, whatever. So recorded, after recording, what did you do? I reduced it into a small information and stored in a flash. What is contained there? Then he can briefly tell. Then we say, okay, where is that information? And if it's played, are you able to identify whatever you've just talked about? The fellow says in the affirmative. Then as the person intending, say, my lord, I applied, or I pray that we have the flash inserted or played accordingly. Now, the good ones and the ones who are experts, they will come with their PC, and then we connect to the court PC. So as it is flowing, we expect produce the device, have it played. Now, as the device is playing, the witness should be in a position to explain chronologically what is happening. Very key. It's not just a matter of putting for us the information and we all go into mute mode and we finish and say, okay, thank you so much. No. The witness must be able to narrate step one. The most recent was one of bank fraud, actually obtaining money where this guy was smart. I think sale of land. He made sure throughout his transactions, he put on a mask. Okay? Now, even when he entered the court, when he entered, they were paying him money in the banking hall, where they went to the teller and so on. But the fella comes with a mask. So because they extracted the footage of the bank, from the bank, to confirm that he's the one who received the money from, so the IO was, actually it was ICT officer of the bank who was explaining. You see, that is where he entered from. From there, he went and sat down. You see, the complainant went to the counter, to the teller. He was there filling the withdrawal slips. You see both of them entering the bulk teller room. And that's how they counted the money and he put in the bag. And now this shows how he exited the bank. That is chronologically explaining the sequence. Nema recorded Nyakana. Some of you were not working, were not born by then. I prosecuted, yes, 2006. 2006, the Nema case where Nyakana was prosecuted. We had it before Deon Zeimana. The destruction of the wetland, Bugorovi. Okay? Current Justice Christine was the prosecutor, not a counsel for Nema, and I was the one prosecuting. But they also recorded that scenario, and we had it to show, including the part where he boxed the police officer. It was all recorded. And when Zeimana saw that, hey, this is how the former boxer assaulted the police officer. Okay? Because it had degradation, but it also had assault, 2 counts of assault. So at the end of the day, the magistrate, having seen how the accused boxed the fellas, that was just good enough. Okay? But the recording officer had to explain step by step by step by step until the end. I think it's the reason even why Supreme Court, when he went for a constitutional petition, Supreme Court had to dismiss his what? Appeal. But evidence, as long as it is able, you're able, the witness must explain the scenarios one by one. And then after that, when it comes to an end, you do what? The person who brought the witness shall then apply to have that evidence tendered in. So if for your prosecutor, apply to have it tendered as prosecution evidence. If it's in civil matters, whether defense or defendant or plaintiff, but at that point after the explanation to the end, that means the witness has ably gone through the whole, he's able to appreciate, owns the content. So now we can apply to have it tendered as evidence. And once that is done, of course, if this was your last witness or whatever, the next is to hand over the witness for cross-examination. Okay? Because then you've carried your information which was at the scene. From the scene, you preserved it in your office. From office, you brought it to court. Court has had a benefit of viewing. And finally, you're satisfied that you have proved your case. That is electronic evidence. And of course, during cross-exam, like I earlier said, defense counsel will be testing those areas of competence, reliability, originality, authenticity, among others. But if you're very sure that your witness is thorough, you should be able to have a good case. And that is how electronic evidence is admissible or administered. So briefly, that is the guide. The locus classicus, Jane Francis, Amongini Jane Francis versus Lucy Okero. And then other cases that have followed. By the practical bit, now the court does not give you the practical bit of it, but I've gone ahead to explain. Without the second bit, your evidence will not be known or received in court. Yes, I thank you so much. That is it I had to share with you in as far as admissibility of electronic evidence is concerned. I will now welcome your responses, positive, negative, whatever it may be, as we dissect the topic. Thank you.
Thank you very much, Mr. Albert Molly. We are very grateful for that very rich discussion or presentation. It's been also very practical. I know that it is your background as a lecturer at LDC that makes your presentations very practical and very easy to grasp. And so our online audience, this is the time for you to be able to raise up your hand in case you have a question. If you have a comment, you can put it in the comment section. You can also put some of the questions in the Q&A chat. We will welcome them. So, do we have any questions?
Yes, I can see my dear classmate.
Yes, we have a comment from Mr. Basalilwa. You could take that on as we wait for the others.
Thank you, Honorable. Current industrial revolution that is giving birth to artificial intelligence, that most of the things may not directly go through the ordinary system. Still, that information, if we are to present it in court, there is need for the steps that are supposed to be taken. Even if we are talking of AI, there must be a central point where this information is controlled from. And it's at that point that whoever is in charge of the system is required to come. Even if it's a robot, there must be a controlling center for those robotics, that the officers or persons who are controlling those robots should come to court and explain how the robots operate. Is it a drone? Is it whichever information? Even if airspace, as we are moving and there is some information being gathered, there should be a point of collection, and whoever is responsible is the one supposed to come and testify. Otherwise, the question would be, how shall we transfer or translate that information? Yes, through AI, but how does it come to the court record? There must be a witness who should be competent to explain all the processes that led to this information and whether it is really authentic and reliable for court purposes. Thank you.
I see another question by Patrick Asiku. I'm not sure whether it was addressed to you or to the previous speaker. Okay, thank you very much. We see an appreciation from Patrick. Thank you, Mr. Molly. I've really liked your presentation. And Viola, yes, we have received your comment, your icon of appreciation. Do we have any questions, any raised hands, any questions before I can discharge our speaker? Our online audience. This is our last speaker, and therefore, there's a raised hand. Yes, Mr. Amanya, can we hear your comment, please? Mr. Manya, go ahead. Mr. Manya?
Yes, you can hear me now?
Yes, we can hear you. Go ahead.
Yes, thank you very much and for that presentation. It seems and this one I want to take a limb because I'm dealing with the case where we are using evidence that was electronically gotten, and where you find in the instances of certain cases that need the proof beyond reasonable doubt, especially murder. Of course, we're talking about some of these crimes. For example, we have certain crimes like what we call the international crimes. For example, human trafficking, child trafficking, and murder and all that, where evidence has been gotten. There is now a challenge in terms of its admissibility. So how then, as a defense lawyer, because my whole intention is to discredit the evidence, but now the prosecution, it is in their interest to make sure that this evidence is tendered in. So you'll find that the law and the way it has been, and especially for me, I practice in both countries. I'm in Kenya. The perspective of the Kenya courts, all the way to the Supreme Court, is that the evidence, especially gotten to such an extent, it has to be corroborated. That's number one. Secondly, there is one of my colleagues, that, especially on confessions. I want my colleague to go and read the case of Abdul Fattah Mohammed versus the Republic versus Abdul Fattah. I will put it in the chart. It is in the Supreme Court, where they have totally addressed the issue. But when you look at the case law that was addressed in Uganda and the case law that was addressed here in Kenya, it gives the paradigm shift in terms of the evidence, especially on admission and confessions. How should they be done? Because there is a laid down procedure. So I think, and I mean, the Law Society, I want to thank you for this, because at the end of the day, it is us as you are the advocates who are really suffering at the behest of the prosecution. Because the presumption is once the case is done, then the courts tend to look at the prosecution as if they have done their case. The last thing I want to say is that, colleagues, we really need to look at the Evidence Act, especially on the current evolution of what we call the privacy and the data protection. How do we then, because when you look at the Computer Misuse Act and the Data Protection Act, how will we put a yardstick on the information, especially when you use the gadgets to collect the evidence? All of those are some of the emerging areas that I think someone commented about it. So we need to look at it, and the Law Society needs also to look at it. How do we then use the evidence? Because, for example, we have gadgets that look like a pen. Does it mean that that gadget can be used to extract evidence? And how can then be the manufacturer effect and all that in the process of making that gadget? So to me, and who has participated in these criminal cases, I'm in this litigation. There is evidence that is corrected by non-professionals. How do we look at that evidence? That someone is not qualified, he is not, he has not mastered the use of that gadget, but he has corrected that evidence. Can that evidence be used to convict someone? And to how much iota can you put to the same? Thank you very much.
Thank you very much for your comment. It is well received by our speaker, Mr. Molly. I see also another comment from Sarah, and I pray Mr. Molly shall be able to handle both your comment and Sarah's comment together. Thank you.
Okay, thank you so much, Ms. Amanya. Your contribution and supplement, it was 2 or 3 in 1. the aspect of crimes committed in the international perspective. Again, it is related to Council of Salira's concern of AI. Okay? For example, cross-border, if this information information that is intended to be relied on, for example, human trafficking, we know mostly our girls are suffering out there. But the question will be, how was this information collected and who collected it? Then we can bring it down to have it admitted in our court system. So we cannot assume that because information is gathered from Iraq or Saudi Arabia, it cannot be. If the victim can disclose, if I worked in a house or a hotel where there are cameras and the footages are extracted, and someone is able to travel all the way, but now even if we don't travel, we can get evidence online, okay? But as long as the officer who accessed that information is able to relate to court how he did it and for what purpose, then we can still have it admitted in evidence. That is one. Now, on the second bit of confessions, it's unfortunate my colleague stepped out, so I may not be in a position to respond. But we appreciate your contributions, and as we wait for the case to be posted, for some of us to enrich ourselves. Then my lecturer and comrade, Sarah Vanenya, we have the Anti-Corruption Court has already handled about 4 cases. One was from Equity Bank. Yes, Equity Bank, this was an account of a Sudanese, South Sudanese who had money in Uganda, and some colleagues or persons went and did whatever they did and stole that money. A conviction is already lying in Anti-Corruption Court. Similar case is in respect of KCB Bank. At least those are the 2 that I know. I may not vividly remember the parties, but I know we have decisions, one from Equity Bank and another from KCB, where money has been siphoned from people's accounts, and these fellas have been successfully prosecuted and convicted. Then I see Rubega Edris. Will evidence recorded by non-professional reasonable person be admissible? For example, recorded by a vigilant person. I think this was addressed to Mr. Kamba. It has nothing to do with the admissibility of electronic evidence. I don't want to stretch into that, though I may have some information, but we reserve it for next time. How can we relay electronic evidence whereby a person who recorded it is not available? Again, this one we are looking at, what is this part where we get a person who is knowledgeable? That you get someone under the Evidence Act, where you use a colleague who is knowledgeable and has been working with the expert to come and testify on his behalf. Pardon? Yeah, that is under expert evidence, under the Evidence Act. That yes, the person who recorded is not available, but the colleague who can be in position to interpret the content can still come and testify on behalf of the person who recorded, as long as he can interpret the content to the expectation of court. Thank you.
Thank you very much, Mr. Molly. Unless there are any other questions or comments, I think we're going to wrap up this session too. Thank you very much, our online audience, for your time with us. I hope that this training has enriched you, or has given you many things to ponder and think about, and even go and make further research. I really want to thank our hosts today, Uganda Wildlife Authority. Thank you for giving us your facilities here to be able to successfully conduct this training. And thank you also for all the other facilities. They have fed us, they have given us They've kept us very comfortable in this place. Thank you so much. We greatly appreciate that. So our online evidence and Uganda Law Society, thank you so much for organizing this training. Criminal law practice is actually one of the major faces of justice in this country. And so it is a field that needs to be given as much attention as possible, because when people are talking about justice, they think about criminal law first. And so equipping the lawyers to be able to do their part in defending Ugandans is very crucial, and it cannot be underestimated. Thank you, Mr. Molly, for taking on more than what we had prepared you for at such short notice. Your training or your skills as a lecturer have come in very handy today. Thank you so much, and all people present here, thank you for your time. I think we have come to the end of this training. Thank you so much. Have a nice afternoon to you all. We have, Mr. Molly is insisting that I introduce that we have here the legal team from Uganda Wildlife Authority. They have been our present participants here in the boardroom. We appreciate you that on top of hosting us, you took off time to be here. Thank you so much. And thank you everyone who has been present. Yes, we have Prosi here and the other members. Maybe the cameraman can just be able to quickly show their presence here as we conclude. Thank you, our participants online. We greatly appreciate Uganda Law Society, Uganda Wildlife Authority, our speakers for today, and everybody who was able to tune in. Thank you very much. Have a pleasant afternoon. Bye-bye.